Uh, I would like to, because see, many of the participants have already joined, and I think we should initiate with the topic. But before we initiate, or before we kickstart the topic, waterfall mechanism, but it is very important for everyone of us to understand that how the liquidation process takes place, or how the things reach to the liquidation stage, and on the basis of which the liquidator has to take care of that who are the secured creditor relinquishing the security interest, or who are enforcing the security interest, and who are the creditors which are or which will be paid in accordance with the hierarchy which is prescribed by the section 53. So as far as this topic is concerned, I would like to go this as far as this topic is concerned, I would like to go ahead with this topic in following manner. So first of all, we will be taking care of the IVC, the provisions of the code. Its preamble is very clear that there is to balance the interest of the stakeholder, to change in the order of priority. This everything is written as far as the preamble is concerned. But now it is very important for us to check that how the practical difficulties arise when there is a amount which is due to the workmen or due to the employees which are not paid by the corporate debtor, which is a contribution, a mandatory contribution towards uh, provident fund or gratuity, right? So there are multiple difficulties which are being encountered during the course of liquidation, and this is what a liquidator or only the liquidator can able to identify that which are the areas or which are the gray areas wherein there is a lack of clarity. Because after rainbow judgment also, every statutory dues or every claimants used to file and they used to move an appeal that why their credit why their claim is not being treated as a secured creditor. And thereafter it was decided that rainbow is having its own isolated case, and no, every statutory dues, if they will be claiming themselves as a secured creditor, and they will be treated equally with the financial creditor who are secured or other secured creditors, then in that case the hierarchy, the manner of distribution which is prescribed under section 53 will itself will be in a big stake of challenge. So as far as this topic is concerned, I would like to deal with the code first of all. I would like to deal with the important definition which are going to be in our way for the course of discussion. I will be taking care of the liquidation regulation also, and we will be moving to the section 53, and we'll be reaching to 53. We'll see which are the burning issues as far as section 53s are concerned. Because when you see section 53, it do have its relevance in section 30 subsection 2 also. When a resolution applicant is preparing a resolution plan, he need to take care of whatever he is offering to the dissenting financial creditors. He need to take care of that whatever he is offering to the operational creditor, that should be in line with section 30 subsection 2 of the code. So this is not only section 53 is relevant at the time when distribution will take place at the time of the liquidation, but 53 always have its own place, or 53 always to have its own relevance when a resolution plan is being perused by the RP, and when RP put it before the COC, he need to take care of whether the amount which is proposed for a dissenting financial creditor and operational creditor, whether it is in line with the requirement of section 30 subsection 2 or not. So it is having its own relevance. So 53 is not having its own say when a liquidator is going to distribute to the claimants, or liquidator is going to distribute to the stakeholders of the corporate debtor, but it do have its own relevance. And there is a clash of interest between a secured financial creditor, those who have assented to a resolution plan, and unsecured financial creditor, or the financial creditor, those who have dissented to the resolution plan, because they have section 30 subsection 2 in hand, which states that the amount which is payable to them should be at least equivalent to the amount which they are going to receive hypothetically when a corporate debtor goes into liquidation, even though we are dealing with a CIRP and a resolution plan. So that is one of the burning issue which I can say that is relevant for every one of us to take care of through the judgments or through the pronouncement, which are again contradictory in nature. The another area which we are going to take care of is when we create charge over the asset of the corporate debtor, there is a provision as far as the Transfer of Property Act is concerned. We used to create security in favor of more than one financial creditors, and they all are not ranking parallelly. So first pari passu charge holder and second pari passu charge holders are there. But now the question is, when company goes into liquidation and when the secured financial creditor, if he is relinquishing the security interest, and if after relinquishing the security interest, when the asset of the corporate debtor become a part of the liquidation estate, then in that case, the pari passu charge holder, or the difference in the hierarchy between a first pari passu charge holder and second pari passu charge holder comes to an end. So that is another point of deliberation or discussion which is going to be taken care of at the end. And one more point which I feel is very important, rainbow judgment and its implication, and thereafter a clarity brought in by the ministry that why income tax dues or why the dues of the customs should not be treated in line with the secured financial creditor. So GST, income tax, they're all claims. Now their act is amended in line with the requirement of the IBC. So rainbow was an exception, and post exception judgment by the Supreme Court, in case of rainbow, there was a Ministry of Corporate Affairs who have demanded the views from the public, and there was you can say a detailed note which was placed in by the Ministry of Corporate Affairs, that why the formula of rainbow or why the rainbow judgment shall not apply in all the matters, or why the statutory dues of the government should not always be treated in equivalent to the secured creditor claims in the hierarchy of section 53. So that is one of the things which we are supposed to take care of. Apart from that, we are supposed to take care of the dues which are payable to the employees and workmen, and apart from their statutory dues of preceding 12-month or 24-month, as the case may be, the amount which is there in the EPFO account or gratuity, this is something which is very clear that these are not the estate of the corporate debtor, and that's why it should be kept out of the liquidation estate. So that is one of the area of discussion and deliberation. But yes, would like to begin the topic in accordance with what we have decided. So as far as the index of the entire session is concerned, the index is divided into three parts. We'll be taking care of the code. We are going to take care of the regulation, more particularly liquidation regulation. We'll be dealing with, for the sake of just brushing up the things, because the one who is practicing as an insolvency professional and dealing in liquidation process or resolution process of the corporate debtor day in day out, for them this is quite a very routine for each of the practicing professional, those who are dealing with this liquidation or the CIRP. But before reaching to section 53, it is important to have a look on the provision for the academic purpose. So IBC is going to be the topmost area for discussion. The code is something which will always prevail before the regulation. We will be dealing with the regulations also. Liquidation regulation is something which we are going to take care of. And after going through the IBC, after going through the code, after going through the liquidation regulation, we will be once again visiting section 53 of the code, and then we'll see the landmark judgment of the Honorable Supreme Court or NCLET and their differing views in case to case basis. So we will be taking care of that discussion on the judicial orders of the Honorable Tribunal or Appellate Tribunal or the Honorable Supreme Court at the end. So begin with the IBC, and I will be taking care of section 30 subsection 2 or some relevant definitions before we reach to section 53 or before we reaching to the liquidation regulation. I'm just sharing screen for the sake of convenience. I hope it's visible. Unless the screen visible?
Yes, sir.
As far as the code is concerned, this is the preamble, and leading to this preamble, it was very much required that rainbow paper should not become an act itself. Though it was passed by the Honorable Supreme Court, but the clarity which was brought in by the ministry was very much required. Now, as far as the preamble is concerned, though it is something which is known to each of us, but the most crucial part of this preamble, looking after the provisions or looking after the topic which is assigned to me for the discussion, that is waterfall mechanism. This was the basic purpose because of which the government has taken or government has made certain sacrifices, and their position is somewhere which is quite after the unsecured financial creditor even. If one can see, that is to balance the interest of all the stakeholders. That is one thing. And when you see the balancing the interest of all the stakeholder, the provision of section 30 subsection 2 is drawn in such a fashion which is taking the interest of not only the assenting but also a dissenting financial creditor. And though operational creditor don't have any say as far as the CIRP is concerned, but what has been provided under section 30 subsection 2 in interest of the operational creditor is indicating the purpose of this code or the object or the preamble of this code. That is to balance the interest of all the stakeholder. Though the balance is not so much convincing, but as far as the provisions of the code is concerned, you will find many where the distribution procedure, which is prescribed under section 53, has got a place in section 30 subsection 2, while COC consider a resolution plan or while RP get a resolution plan from a resolution applicant, and before that RA gets a name of successful resolution applicant, he has to make sure that the resolution plan is in compliance with section 30 subsection 2, and that is what we can identify. That is the government intention of bringing this code to balancing the interest of all the stakeholders. There was a change in the priority, and that is what provided. There is an alteration in the order of priority with regards to payment to the government. We used to deal with the liquidation in the 1956 Act. Government dues was a priority dues. It was a due payable to the government which was in priority to the other creditors. Today, when we see the hierarchy, the government dues are coming in the 5th position. After that CIRP cost or liquidation cost, after the payment to 24-month overdue payment of the workers, employees payment, and the workman dues is in line with the amount which is payable to the secured creditors, subject to the condition if the secured creditor has intimated liquidator that he don't want to enforce the security interest and he want to relinquish it. The moment he intimate the same, it becomes a part of the liquidation estate. And once it became a part of the liquidation estate, all the secured financial creditors shall be ranking parallelly. They will be ranking pari passu, and there is nothing like a first pari passu or second pari passu charge. And that is one of the area or one of the point of deliberation wherein there is a judgment from the NCLAT and Supreme Court also. Alteration in the order of the priority with regards to payment of the government dues, and that's why here the rainbow has made some disturbance. And many times it happens that the court of law, the tribunal used to ask whether the resolution plan is rainbow compliant or not. So not every statutory dues will get its position, or not every statutory dues will be called as or treated as a secured debt. And if this is going to be the case, it will hamper the distribution procedure, which is prescribed under section 53 and which is intentionally created in such a manner so that the objective of the code gets fulfilled. Now, as far as section 3 is concerned, since when we are going to deal with section 53 clause A, we are going to see that the first distribution will be for the sake of matching up to defray the CIRP expenses or liquidation expenses. So whatever expenditure the IRP or the RP has incurred during the course of insolvency resolution process and the liquidator has incurred during the course of liquidation, that is going to be defrayed in full. So that is something which we need to take care of. And this is there in section 3, subsection 30. Secured creditor we will be dealing with section 53, a creditor in whose favor the security interest is created. And there is again, you can say there is again a mismatch of views, or there is again a variation in the views when the charge is registered and when the charge is not registered. That is one of the point, whether it is going to be a void against the liquidator or not. If there is a secured creditor but the charge is not registered with the ROC, whether the records of the IU can be relied upon in that case, or whether the SARSAI registration will serve the purpose or not, that is going to be taken care of. But yes, secured creditor is a creditor in whose favor the security interest is created. And when we see security interest, Rainbow Papers judgment, and that's why I would like to say the word transaction has got the relevance. The charge is created by the act of parties as well as by the operation of law. But when its charge is created by the operation of law, the language of that statute is required to be read with, whether it is a state legislature or something which is either it is a state act or central act, but it is required whether it is subject to IBC or not. And that's why there is a difference between what was held by the Honorable Court in GVET and in Maharashtra VET. And that is what we are going to deal with in Jet Airlines or Jet Airways. Security interest means right, title, or interest or claim of the property created in favor of, provided for a secured creditor by a transaction. And when you see a transaction, there is a agreement, an arrangement between a borrower and lender. There's nothing like an operation of law, unlike what we have seen in the Rainbow judgment. Security interest means right, title, or interest or a claim to a property created in favor of or provided for a secured creditor by a transaction which secures payment of performance of an obligation, including mortgage, charge, hypothecation, assignment, encumbrance, or any other agreement or arrangement securing payment or performance of any obligation of any person. So this is going to be helpful when we will be dealing with the Rainbow judgment, the reasons of that judgment, and the grounds because of which no other statutory dues can again take a shelter of Rainbow and claim its claim as a secured credit or as a secured creditor. Apart from that, we need to deal with section 5, which deals with the CIRP cost, that is insolvency resolution process cost. When we deal with the CIRP cost, it includes an amount by the way of interim finance or cost associated in raising such finance. The provision of interim finance is just in order to keep the corporate debt running. So whatever is the amount of finance which the IRP has raised, so whatever may be the cost of that raising that borrowed sum or honors fund, whatever, that cost of that capital will be treated as a cost of CIRP. So it will be a part of the CIRP cost, amount of any interim finance and a cost incurred in raising such finance. So that will be defrayed first. Fees payable to any person acting as an RP, cost incurred by RP in running the business of the city as a going concern, cost incurred at the expense of government to facilitate the insolvency resolution process. Other cost as may be specified by the board, so that can be dealt in the regulation. Liquidation cost, cost incurred by liquidator during the period of liquidation, subject to such regulation as may be specified by the board. Now directly we can reach out to section 30 subsection 2. And this is what I said, that 53 do have its relevance with section 30 also. Because when we deal with section 30, there are the stakeholder known as operational creditors, even though they don't have any say as far as the COC is concerned. Unless COC itself is comprised of the operational creditor, they don't have any say or interference as far as the approval of resolution plan is concerned, in case if the COC is consisting of the financial creditors. So as far as this section 30 is concerned, section 30 states that resolution applicant may submit a plan along with an affidavit that he is eligible under 29A to the RP which is prepared on the basis of the information memorandum. Now, this is something which is quite crucial, that RP shall examine each plan received by him to confirm that each plan provides for the payment of insolvency resolution process cost in a manner as may be specified by board in priority of the other debt of the corporate debtor. This is something which is not area of concern, but now this is the area of concern. Provides for repayment of debt of operational creditor. Now here you need to compare what this operational creditor would have received if this corporate debtor goes into liquidation as per the hierarchy which is prescribed under 53. Or what if the resolution amount which is proposed by the resolution applicant, if this would have distributed in accordance with the hierarchy prescribed under 53, what an operational creditor would have received? That mathematical formula you need to apply in order to give a mandate to that plan before the COC to consider and to vote upon. For the payment of debt of the operational creditor in such a manner as may be specified by the board, but which shall not be less than the amount to be paid to such creditor in the event of liquidation of the corporate debtor under 53. Now, this is something which is, as far as regulation 35 is concerned, it is the valuation which is required to be done by the registered valuer. On the basis of the registered valuer valuation report, both fair value and the liquidation value is assessed. So, as far as the amount payable to the liquidator is amount payable to the operational creditor is concerned, what RP has to take care of is what amount this operational creditor could have received if this company goes into liquidation. But this is just a theory, because practically there is a huge time gap between this stage when the resolution plan is being considered and that stage when the liquidation takes place and distribution during the course of liquidation take place. The asset value gets deteriorate. The valuation is not mandatorily required, but advisable to get the valuation again done during the course of liquidation. So what you anticipate that what this operational creditor could have realized if this corporate debtor goes into liquidation is something which is quite difficult when you think from that viewpoint. But yes, it clearly states that section 30 subsection 2 clause B, which states that provides for the payment of debt of operational creditor in a manner as may be specified by the board, but that shall not be less than the amount to be paid to such creditor in the event of liquidation of the CD. Amount to be paid to the creditor in the event of liquidation of the CD, or the amount that would have been paid to such creditor if the amount to be distributed under the plan had been distributed in accordance with the order of priority under 53. So the comparison is between if the city goes into liquidation, what OC would have received versus the amount which is proposed by the applicant in the plan. If the amount gets distributed in accordance with the hierarchy prescribed under 53, at least whatever amount is being calculated with regards to payment to the operational creditor, the OC should get at least that amount when plan is being placed by the RA and when RP place it before the COC for its consideration and approval. Now, this is something which is a subject matter of dispute. Provides for the payment. Now, this is whichever is higher, and provides for the payment of debt of financial creditor. Provides for the payment of debt of the financial creditor who do not vote in favor of the plan. So dissenting financial creditor we are talking about. And this is something which I am not so much convinced and convenient with. In such a manner as may be specified by the board, which shall not be less than the amount to be paid to such creditor in accordance with subsection 1 of 53 in the event liquidation of the corporate debtor. Because when a secured creditor is concerned, secured creditor under section 52 have a right to intimate the liquidator that he don't intends to relinquish the security interest and he want to realize the security interest. So meaning thereby, if this corporate debtor goes into liquidation, whatever a financial creditor as per section 53 was about to get, that amount should be at least an amount to be tendered by the applicant in the plan. This is what provided here. The payment of debt to financial creditors who do not vote in favor of the plan in such a manner as may be specified by the board, which shall not be less than the amount to be paid to the creditors in accordance with subsection 1 of 53 in the event of liquidation of the corporate debtor. And because of this, there is a high possibility that the assenting financial creditor has to sacrifice their part. Because when you see their stake, as far as the distribution is concerned, their voting share, when you see this particular proportion, a dissenting financial creditor always be in a position to get more than what the secured creditors, assenting financial creditor used to get while approving a resolution plan. So I believe that here, this is what stated, that the payment of debt to the financial creditor, those who have not voted in favor of the plan in such manner as may be specified by board, which shall not be less than amount to be paid to such creditor in accordance with subsection 1 of 53 in the event of liquidation of the corporate debtor. This is something which encourage liquidation. This is my personal views, that if I, being a dissenting financial creditor, but because of the provision of section 30 subsection 2 clause B, which gives me a kind of facility, or which facilitates me to get an amount which should be at least an amount which I would have received if this corporate debtor goes into liquidation. Because in liquidation, I was having both the choices open. I was having the right to relinquish, and once I relinquish, I'll be treated in par with the other secured creditors, irrespective of the value of the security registered in my favor or created in my favor. And other option which I was having is to enforce the security interest, to realize the security interest. So I always have the position, a better position, by dissenting any resolution plan. So that is what I can make out of this amendment in the code. That payment of the debt of the financial creditor who do not vote in favor of the plan in such a manner as may be specified by the board, but that shall not be less than the amount to be paid to such creditor in accordance with subsection 1 of 53 in event if the corporate debtor goes into liquidation. And one more thing, if you read with regulation 38 of Insolvency and Bankruptcy Board of India, insolvency resolution process for corporate persons regulation, you will find the dissenting financial creditor shall be paid before the assenting financial creditors. Now, this is very important. And again, as I said, that 53 do have its relevance during the course of consideration of the resolution plan. The COC may approve a plan by a vote of not less than 66% voting shares of financial creditor after considering its feasibility and viability, the manner of distribution proposed, word which is used is which may take into account the order of priority amongst creditor as let down under subsection 1 of 53. Now, this makes a very important question. 53 deals with the distribution, or the manner of the distribution, the proportion or the hierarchy, the waterfall, on whom the water is going to fall first. So that is something which 53 talks about. And there is no mandatory rule which says that while proposing a resolution plan, I have to take care of that my plan should be proposed in such a manner as if 53 is something which I have to comply with, or whatever I'm proposing in the plan should be in line with what is there in section 53. It is the commercial call of the COC, and that's why the word which is used is may, and the Supreme Court has emphasized on this. We will be dealing into the same. The committee of creditors may approve a plan by a vote of not less than 66% voting shares of financial creditors after considering its feasibility, viability, the manner of distribution proposed, which may take into account the order of priority amongst creditor, which may take into account the order of priority amongst creditor as let down under subsection 1 of section 53, including priority, value of the security, interest of the secured creditor, and such other requirement as may be specified by the board. Now, because of subsection 4, because of subsection 2, when I as an RA, I as a resolution applicant, when I propose a resolution plan, what I need to take care of is amount which I'm tendering to my operational creditor, because clause B clearly states that section 30 subsection 2 clause B, that whatever I'm giving to the operational creditor should not be less than the amount to be paid to such creditor if the company goes into liquidation, or if the amount which is proposed in the plan, if that amount get distributed, the amount as proposed in the plan, if the amount get distributed in accordance with section 53 or whichever is higher, I should get at least that amount, or I should propose at least that amount while making payment to my operational creditor. This is what section 30 subsection 2 all about, which do have its significance, or section 50 to 53 do have its significance while reading section 30 subsection 2, because the same is the case with the dissenting creditors also, that whatever amount which you are proposing to the creditor, those who have not assented to resolution plan, it should be at least an amount which should have been paid to them when the payment would have been made during the course of liquidation. That is in accordance with 53 subsection 1. And in 53 itself, it's always an option available with a secured creditor. If the dissenting creditor is also a dissenting secured creditor, then in that case, an option which is available with him to contest the amount which is proposed in the plan is section 52. What in case if he would have realized the security interest? What in case if he would have relinquished the security interest? And that's why while tendering a plan, this mathematical things are supposed to be taken care of. Payment of debt to financial creditor who do not vote in favor of the plan in such manner as may be specified by the board, which shall not be less than the amount to be paid to such creditor in accordance with subsection 1 of 53 in event if the liquidation of the corporate debt will take place. This was relevant. Apart from that, there is section 36, which is quite crucial, and that talks about the liquidation estate. The reading of the section 36, especially subsection 3, this is something which is quite important when we are going to ultimately deal with PF and ESIC issues and gratuity issues. For the purpose of liquidation, the liquidator shall form an estate of the asset mentioned in subsection 3, which will be called as a liquidation estate in relation to the corporate debtor. The liquidator shall hold the liquidation estate as a fiduciary for the benefit of all the creditors. Subject to subsection 4, liquidation estate shall comprise of all liquidation estate, which shall include any asset over which the CD has ownership rights, including all rights and interests therein, as evidenced in the balance sheet of the CD, or which can be made out of the information utility, records in the registry or depository recording securities of the corporate debtor, or other means as may be specified by the board, including shares held in subsidiary of the corporate debtor, which is investment again. Asset that may or may not be in the possession of the CD, but ownership stays with the CD, including but not limited to that is encumbered asset. Encumbered asset is an asset on which the company has created a security. So encumbered asset shall form a part of liquidation estate, subject to the condition if the secured creditor in whose favor the asset is created as a security has intimated the liquidator that he relinquished the security interest, then only it shall form a part of the liquidation estate, otherwise not. Tangible asset, whether movable, immovable, that shall also form a part of the liquidation estate. And the liquidator generally get an idea of this asset from the information memorandum, which is prepared in accordance with section 29. Intangible asset, including but not limited to intellectual properties, securities including shares held in subsidiary of the CD, and financial instrument, insurance policy, and contractual rights. Assets which are subject to determination of the ownership by a court, any asset or their value recovered through proceedings of avoidance transaction. Now, this is something which is very important, because what happened, this avoidance transaction application keeps on running even after the liquidation take place, or even after the dissolution take place. The asset or their value recovered through proceedings for avoidance transaction, any asset of the CD in respect of which the secured creditor has relinquished the security interest. Many times happen that corporate debtor is sold as a going concern, but the avoidance transaction application is pending. So how that is going to be treated, that is what required to be stated when the liquidator file its report before the adjudicating authority. Asset which are subject to determination of the ownership by court, asset and their value recovered through proceedings for avoidance transaction, asset of the corporate debtor in respect of which a secured creditor has relinquished security interest, property belongs to or vested in the corporate debtor as an insolvency commencement date, all proceeds of liquidation as and when it get realized. But following shall not form a part of the liquidation estate. Estate owned by third party, but in possession of the corporate debtor. Held in trust, bailment contract on which I don't have any ownership rights. All sum, now this is very relevant. All sum due to workman or employee from provident fund or pension fund or gratuity fund. Now you cannot consider this as a part of the liquidation estate. This is not the estate. There is a provision of section 18 of the code which clearly states that when you deal with section 18 of the code, section 18 states that IRP take control and custody of the asset over which the corporate debtor has ownership right. And this asset which we are talking about under section 36, corporate debtor cannot be presumed to have an ownership right over such asset. This is very relevant as far as the discussion is concerned at the end when we will be dealing with the judicial pronouncement. I'm talking about this one. All sum due to workman employee from a provident fund, pension fund, gratuity fund, that shall not form part of the liquidation estate. And hence, this amount is not available for distribution when we deal with section 53 waterfall mechanism. Any contractual arrangement which did not stipulate transfer of title but only use of asset, or such asset as may be notified by the government. This is something which was relevant, and that's why we read out this thing. Apart from this, let's deal with section 52 also, which is always going to be the focal point of understanding when we will be dealing with section 53. 52 talks about that a secured financial creditor to have this option available, that he may either opt for relinquishing the security interest, or else he may be having this right to enforce the security interest. A secured creditor in liquidation proceedings he may relinquish the security interest. And the moment he relinquishes, so he need to intimate within 30 days from the liquidation commencement date, when that person will be filing its claim as a financial creditor, as a secured creditor, he need to intimate this fact to the liquidator whether he want to realize or whether he want to relinquish it. If he realize it, that asset shall not form a part of liquidation estate. But if he relinquish it, the asset shall form a part of the liquidation estate, and he will be getting, in accordance with section 53 subsection 1, which comes in second hierarchy along with the workman dues of proceeding, 24 month, and that shall rank in line with the secured creditors, relinquish its security interest to the liquidation estate, and receive proceeds from the sale of asset by the liquidator in a manner as specified in 53. The other option which is available with a secured creditor is to realize its security interest in manner specified in this section. But suppose if he intimate that he is realizing the security interest, in that case, that shall not form a part of the liquidation estate. But when he realized the security interest, he need to pay the overdue amount of the CIRP cost, his proportion, towards the liquidation cost, his proportion. And this is what provided. Where the secured creditor realizes security interest under clause B of subsection 1, he shall inform the liquidator of such security interest and identify the asset subject to such security interest is realized. So it is also the liquidator who need to reconcile from the records of the corporate debtor that whether a property which a secured creditor is claiming that he is having a security interest over that property, whether that amount, whether the property is created in favor of the secured creditor or not. This information can be made available through IU, or this information can be gathered through the books and paper of the corporate debtor. So where the secured creditor realizes the security interest under subsection 1, he has to intimate the liquidator. He shall inform the liquidator of such security interest and identify the assets subject to any security interest to be realized. Before any security interest is realized by secured creditor, under subsection under this subsection, the liquidator shall verify the security interest and permit secured creditor to realize only such security interest, the existence of which can be proved through either the records which are available in IU or any other means as may be specified by the board. The secured creditor may enforce or realize or settle or compromise or deal with the secured asset in accordance with such law as may be applicable to security interest being realized and to the secured creditor and apply the proceeds to recover the debt due it. But this is important that when he moves or when he opts to stay out of the distribution procedure or when he decide to realize the security interest, he may enforce it, he may realize it, he may settle, he may compromise or deal with the secured asset in accordance with such law, including SARFASI, as available as applicable to the security interest being realized and to the secured creditor and apply the proceeds to recover the debt due to it. But he need to pay the proportionate amount towards the liquidation cost. He need to pay the proportionate amount to the CIRP cost if it is unpaid. If in the course of realizing a secured asset, the secured creditor faces resistance from the corporate debtor or any person connected therewith in taking possession of or selling or otherwise disposing of the security. The secured creditor may move an application before the adjudicating authority to facilitate the secured creditor to realize such security interest in accordance with the law for the time in force. So always you do have what we have section 19 application when we are not getting necessary cooperation or when in case of such a roadblock situation, the same is available to a secured creditor also in case if he face a resistance from the CD or from any person connected therewith in taking possession. The adjudicating authority on receipt of the application from a secured creditor may pass an order as may be necessary to permit secured creditor to realize security interest in accordance with the law for the time in force. Whereas the enforcement of the security interest under subsection 4 yields an amount by the way of proceeds, which is in excess of the debt due to secured creditor, then he shall be made accountable to the liquidator. He shall be accountable to the liquidator for such surplus, and surplus shall form a part of the liquidation estate. Tender to the liquidator any surplus fund received from the enforcement of secured asset. The amount of insolvency resolution process cost due from secured creditor who realize their security interest in manner as provided in this section shall be deducted, and not only this, I would like to say even a cost associated with regards to liquidation also, that shall also be proportionately deducted. The amount of insolvency resolution process cost, if it is due from a secured creditor who realize security interest in the manner as provided in this section, shall be deducted from the proceeds of any realization by such secured creditor, and they shall transfer such amount to the liquidator to be included in the liquidation estate. And last one, where the proceeds of realization of the secured asset are not adequate to repay the debt. Now, this is something a pros and a cons of what we can say of your own call. Being a secured creditor, you do have both the alternatives available as far as section 52 is concerned. You can realize the security interest and stay out of section 53, and else you can surrender. You can relinquish the security interest. The property over which security interest is created, that shall form a part of the liquidation estate, and you will be you will be ranking parallelly with the other secured creditor, and you will be high in hierarchy. But suppose if you have decided not to relinquish the security interest, but to realize it. If you have decided to relinquish, then it will not make any difference. But if you have decided to realize the security interest and the amount which you have gained out of that realization, if you have enforced the security interest, but the proceeds of the realization of the secured assets are not adequate to repay the debt owed to secured creditor, the unpaid debt of secured creditor shall be paid by the liquidator in a manner specified in clause E of subsection 1 of 53. You will be ranking parallelly with the government dues, which is in the fifth stage. After the payment of CIRP and liquidation costs, there comes workman dues of preceding 24 months up to the liquidation commencement date, and they will be ranking parallelly with the secured creditors. Then comes the employee dues of preceding 12 months prior to liquidation commencement date. Then comes unsecured creditor. Then comes government dues, crown debts. And along with that government dues, the unrealized portion, which is or which could not be realized through the enforcement of security interest, which is very clearly stated that where the proceeds of the realization of the secured asset are not adequate to repay the debt owed to secured creditor, the unpaid debt of such creditor shall be paid by the liquidator in a manner specified in 53(1) clause E, and which will not get the same footing which the other secured creditors are getting as a secured creditor by relinquishing the security interest. This is section 52. Last to deal with is 53 before we go to the regulation. Distribution. As far as the distribution is concerned, now basically this is the point of discussion and deliberation between us. But as I said that as far as the index of the session is concerned, or the agendas of discussion is concerned, this was required to be written, or this was required to be referred once. The moment we will be out from this, we will be taking care of the liquidation regulation, which will be equally important. Timeliness, which is equally important, irrespective whether it is complied, whether it is directory or mandatory. But for the sake of this session, it is important that we should visit those provisions, or we should visit those regulations before dealing into the practical aspects wherein there are the conflicting judgments which are being passed. Distribution. As far as the distribution is concerned, notwithstanding anything to the contrary contained in any other law, in any law enacted by the parliament or a state legislature for the time being in force. This indicates the supremacy of 53. The proceeds from the sale of liquidation asset. And mark my words, the property which is realized or the property which a secured creditor has already informed to the liquidator that being a secured creditor, the asset over which the corporate debtor has created a security interest in his favor. He don't want to realize, he don't want to, you can say, he want to realize the same. He want to enforce the same. In case if he want to enforce the same or realize the same, then in that case, the property shall not be treated as a property of the corporate debtor, or that shall not form a part of the property or the liquid, that shall not form a part of the liquidation estate. Relinquishment may give asset as a part of the liquidation asset, but suppose if the secured creditor has not relinquished it and has decided to enforce it, realize the same, then it shall not form a part of the liquidation assets. So as far as the proceeds from sale of the liquidation asset is concerned, proceeds from the sale of liquidation asset is concerned, and that's why section 36 was very crucial for each of us to know that which property shall form a part of the liquidation asset. Proceeds from the sale of liquidation asset shall be distributed in following order of priority and within such period and in such manner as may be specified, namely insolvency resolution process cost and liquidation cost to be paid in full. There is no ambiguity or there is no question pertaining to the same. Insolvency resolution process cost or liquidation cost to be paid in full. The question emerges here. The following debt shall be ranking equally between and amongst the following. Workmen dues for a period of 24 months preceding the liquidation commencement date, and debt owed to secured creditor in the event a secured creditor has relinquished the security interest in a manner as set out in section 52. It will not make any difference as the amount if the amount is sufficient. And the amount is sufficient, then it will not make a much disturbance. But if the amount is not sufficient, this question always emerge. First pari passu charge holder was SBI. Second pari passu charge holder was Bank of India. ICICI was not the first pari passu or was not the second pari passu charge holder. The distribution mechanism is prepared, is drafted in such a manner. There is no sub-classification between, or there is no subdivision of this class that owed to secured creditor in event such secured creditor has relinquished the security in a manner set out in 52. You can have a sub-classification of secured creditor only when a secured creditor has decided to enforce it, realize it. But once a secured creditor has communicated liquidator that he want to relinquish it, then he need to make sure, or he need to accept one more fact, that the further classification among this class of secured creditor shall not be permissible. This is what we are going to deal with. Third comes wages and unpaid dues owed to employees other than a workman for the period of 12 months preceding the liquidation commencement date. Financial debt owed to unsecured creditor. Now, this is the hierarchy. Financial debt owed to unsecured creditor. Now, suppose there is a secured creditor. There is a secured creditor, and the case is pertaining to consideration of resolution plan. Now, if it is a case pertaining to the consideration of resolution plan or approval of the resolution plan, what as a secured creditor I am going to think? If I vote, if I cast my vote in favor, what this plan is proposing. If I cast my vote against what this plan is proposing versus what I'm going to realize under section 52 versus what I'm going to realize if the distribution will take place and CD goes into liquidation, and what I'm going to get out of section 53(1). And that's why I said that the 53 do have its significance while considering a plan. Because while considering a resolution plan, as a resolution applicant on one side or as a RP on another side, we are supposed to take care of the compliance of the provision of section 6, section 30, subsection 2 for both the operational creditor as well as a dissenting financial creditor. Suppose if a dissenting financial creditor is secured, then he need to compare the amount which he is getting in the plan with section 52 and with 53. What if the distribution takes place as per 53 and he relinquishes the security interest? And what in case if he enforce or realize security interest, and what he is going to get? So if he is a secured creditor and a secured dissenting financial creditor, he need to compare the amount which he is getting by the way of resolution plan with 52 and 53. But if he is a dissenting unsecured financial creditor, then he need to compare that what amount he would have received if this company would have been gone into liquidation. Because if company would have been gone into liquidation, then he was standing at the fourth footing. The financial debt owed to unsecured creditor. But it is ranking before the amount paid to the government. Still, the unsecured financial creditor is coming before the amount payable to the government. So government dues, and this is the rationale, or this is the objective, or this is the preamble all about change in the priority of, or there is a change in the priority of payment when we compare with the Companies Act 1956, what it was proposed. Any amount due to central government, state government, including amount to be received on account of consolidated fund of India, consolidated fund of state, in respect of the whole or part of the period of 2 years preceding the liquidation commencement date. And this is again section 52, which is quite important. That as a secured creditor, if I do not relinquish the security interest, and if I realize the security interest by enforcing the same, and suppose if I fail to recover the entire amount, then whatever amount, the residual amount which I have not recovered out of selling that asset over which the company has created security in my favor, I will be ranking with the government dues. Debt owed to a secured creditor for any amount unpaid following the enforcement of security interest. Debt owed to secured creditor for any amount unpaid following the realization or enforcement of security interest. Remaining debt and dues, preference shareholder, because they are preference as far as the equity shareholder is concerned, they will be ranking at the last. Now, this is what, again, a subject matter of dispute, a contractual arrangement between a recipient under subsection 1 with equal ranking, contractual arrangement between recipient number 1 with equal ranking, if disrupting the order of priority under that subsection, shall be disregarded by the liquidator. And here we are going to deal with the case of pari passu charge holder. Any contractual arrangement between a recipient under subsection 1 with equal ranking, if disrupting the order of priority, that subsection shall be disregarded. That subsection, it shall be disregarded by the liquidator. The fee payable to the liquidator, that will be proportionately deducted. The fee payable to the liquidator shall be deducted proportionately from the proceeds payable to each class of recipient, and the proceeds to the relevant recipient shall be distributed only after such a deduction. Workmen will be having the same meaning as assigned to it under section 326 of the Companies Act 2013. And it is one more thing which is clarified by the way of this explanation. Each stage of the distribution of the proceeds in respect of the class of recipient that rank equally, each of the debt will either be paid in full or will be paid in equal proportion within the same class of recipient if the proceeds are insufficient to meet the debt in full. So as far as combination is concerned, it is there in B as well as in E. One, you can see 53 subsection 1 clause B, which talks about the following debt shall be ranking equally between and among the following. One is workmen dues for a period of 24 months preceding the liquidation commencement date. Debt owed to secured creditor in event the secured creditor has relinquished the security interest. Here the proportionate payment in case if the amount is not sufficient to pay the amount in full. And if the amount is sufficient, then probably this is not going to be the case of proportional payment. And one more thing is E, 53 subsection 1 clause E, which talks about the following dues shall rank equally between and among the following: amount due to central or state government, including amount to be received on account of consolidated fund of India or government, the state government, in respect of the whole or any part of the period of 2 years preceding the liquidation commencement date, and they will be ranking parallelly with the amount of debt owed to a secured creditor if that secured creditor has enforced the security interest but failed to realize the full amount. So whatever amount of debt due to secured creditor which is unpaid following the enforcement, they will be ranking equally with the government dues. And this is what the explanation says, that the amount will be paid in full if there is a sufficient amount of distribution. Each stage of distribution of the proceeds in respect of the class of recipient rank equally. Each of the debt will be either be paid in full or will be paid in equal proportion within the same class of recipient if the proceeds are insufficient to meet the debt in full. So this was a limited discussion as far as the code is concerned. Post this discussion, we need to take care of what the regulation says, liquidation regulation. And post liquidation regulation, we will be taking care of all the burning issues, whether it is pertaining to PF, ESIC, gratuity, in line with liquidation estate, We will be dealing into the case of how a charge created in favor of a secured creditor, which is ranking in first, and second pari passu charge holder will lose their difference when a secured creditor relinquishes the security interest. That is one of the point of discussion. We'll be taking care of why the government dues should be treated as a government dues only, unless otherwise provided. That is something which we are going to take care of while dealing into the judgment. But before that, we need to take care of the liquidation regulation. If something is required to be discussed in between, I would like to keep the forum open, and I would like to have your views also in this connection. Participants can share their own experience because that is going to add a value to this session. Probably that will give us an edge of further discussion to the topic, either which we have discussed or which we are supposed to discuss in the forthcoming time. Apart from that, we will be taking care of the liquidation regulation if there is a thing to discuss about further. Now, as far as the regulation is concerned, the foremost focus is on the liquidation cost, which we have read out during the course of reading this definition of what amounts to liquidation cost. So it's CIRP and liquidation cost. So liquidation cost do have its own definition in section 5 subsection 16, but that will also cover the fees payable to the liquidator under regulation 4. That is forming a part of the liquidation cost. Apart from that, a remuneration payable by the liquidator under sub-regulation 1 of regulation 7 if they engage a professional. Cost incurred by the liquidator under subsection 2 of regulation 24 for verification of the claim. Cost incurred by the liquidator for preserving and protecting the asset property affects actionable claims, including secured asset of the corporate debtor, because liquidation never takes place overnight. So whatever may be the amount incurred by the liquidator in order to preserve and protect the asset property of the corporate debtor, including secured asset of the CD. Cost incurred by liquidator in carrying on the business of the CD as a going concern. Rarely happens. Interest on interim finance for a period of 12 months or period from liquidation commencement date till the repayment of the interim finance, whichever is lower. So either the interest on the interim finance for a period of 12 months or period from the liquidation commencement date till repayment of the interim finance, whichever is less. The amount repayable under subsection 3 2A is what we are going to take care of. The other cost incurred by the liquidator, which is essential for completing the liquidation process. But it is provided that a cost, if any, incurred by the liquidator in relation to the compromise and arrangement under section 230 of the Companies Act shall not form a part of the liquidation cost. So this is always an initial effort. Sell as a going concern or inviting a scheme of compromise and arrangement to bring the corporate debtor out of the liquidation. But any cost associated with regards to the compromise and arrangement shall not form a part of the liquidation cost. So this is something what we are reading is going to be helpful while dealing with section 53 again. Liquidation cost to be defrayed in full. Now this is 2A, which I was talking about, where the committee of creditors do not approve the plan under sub-regulation 3 of regulation 39B. I'm talking about the CIRP, I'm talking about the COC, and I'm talking about the COC non-approval for any plan. The liquidator shall call upon the financial creditor, being a financial institutions, to contribute the excess of the liquidation cost over the liquid asset of the CD as estimated by him in proportion to the financial debt owed to them by the CD. So it happens where a COC is not considering the approval of the resolution plan, then always a company is going to be in for, or company will be opted for the liquidation But it happens that when the available asset, the realizable value of the available asset is not sufficient to meet the liquidation expenses even, the liquidator shall call upon the financial creditor, being the financial institutions, to contribute the excess of the liquidation cost over the liquid asset of the CD as estimated by him in proportion to the financial debt owed to them by the corporate debtor. Eligibility we are not dealing with. Power and function of the liquidator I am not dealing with. Yes, this is something from where one should start. But again, we are just going to touch upon the provisions, or we are only going to touch upon the regulations, and which will not go in detail unless it is required. Public announcement. This public announcement is required to be made within 5 days from the date of the appointment. Public announcement is for the purpose of calling upon a stakeholder to submit their claim or to update their claim during the CIRP, which they have submitted during the course of CIRP as on the liquidation commencement date. So the public announcement with an aim of, or with an intent of, to call upon the stakeholders so that they can submit their claim or they may update their claim which was submitted by them during the course of CIRP. Provided that the last date of submission of the updation or submission or updation of claim, which shall be 30 days from the liquidation commencement date. Now, why this is important? Because right now we were reading section 52. If I'm a secured creditor and want to enforce the security interest, want to realize the security interest, when I will be submitting my claim, I will be intimating the fact to the liquidator that I don't want to relinquish the security interest, but I want to enforce or I want to realize the security interest. So that's why this is important, that the last day for submission or updation of the claim will be 30 days from the liquidation commencement date. Provided where the stakeholder does not submit its claim during liquidation process, the claim submitted by the stakeholder and duly collated by IRP or RP as the case may be during the CIRP shall be deemed to be a submitted claim under section 38. Announcement shall be published in English and vernacular language newspaper. Anyways, this is not so vital. On website of the corporate debtor and the IBVI. This is not relevant. Preliminary report, why it is relevant? Because along with the preliminary report, I have to submit my asset memorandum also. When we see a preliminary report, the liquidator shall submit a preliminary report to the adjudicating authority within 75 days from the liquidation commencement date. While submitting the preliminary report, I need to specify the capital structure of the CD, estimate of the asset and liability as on liquidation commencement date based on the books of the CD. If the liquidator has reasons to believe to be recorded in writing that the books of the CD are not reliable, he shall also provide such estimate based on reliable records and data are otherwise available to him. So anyways, this is mere theory. Early dissolution, it happens many cases. And it is preferable also, but it is very clearly stated that early dissolution can only be possible after the submission of the preliminary report. If any time after the preparation of the preliminary report, so this is the beginning. And this preliminary report is required to be submitted to the adjudicating authority within 75 days from the liquidation commencement date. And any time after the preparation of the preliminary report, if it appears to the liquidator that the realizable property of the CD are insufficient to cover the cost of the liquidation process and affairs of the CD do not require any further investigation, he shall consult the consultation committee. And if it is advises for early dissolution, he may apply along with a detailed report incorporating the views of the consultation committee to the adjudicating authority for early dissolution of the CD and for necessary directions in respect of such dissolution. So this is possible when practically it is not advantageous to continue with the liquidation process, or even when the liquidation process will take place, but the realizable property of the CD is not sufficient to cover the cost of the liquidation itself, then in that case, he shall consult the consultation committee And if it is advisable for early dissolution, he may apply along with the detailed report incorporating the views of consultation committee to adjudicating authority for an order of early dissolution of the CD and for necessary directions in respect of such a dissolution. Progress report, again, bit relevant. Liquidator shall submit progress report in a format stipulated by board. The first progress report within 15 days at the end of the quarter in which he is appointed. So if I have been appointed in the month of November, I will be submitting this report by 14th of January. Subsequent progress report within 15 days after the end of each quarter, provided that if the insolvency professional ceases to act as a liquidator during the liquidation process, he shall file progress report within 15 days of its cessation up to the quarter end, for the quarter up to the date of its cessation. So he need to file at the time of his appointment. Whenever the quarter is going to close within 15 days, this is what at the time of his appointment. First progress report within 15 days after the end of quarter in which he is appointed, and the last when he ceases, provided if the insolvency professional ceases to act as a liquidator during the liquidation process, he shall file the progress report for the quarter up to the end of his cessation within 15 days of such cessation. The progress report shall provide all the information which are relevant to liquidator, which are relevant to the liquidation for the quarter, including for the quarter. So it is required to be reported within 15 days from the end of the quarter. Appointment, tenure of appointment, cessation, statement indicating the progress, that is settlement of the list, details of any property that remain unsold or sold, distribution made, distribution of unsold property, detail of fee or remuneration including the fee due to and received by liquidator with a description of the activities carried out by him, remuneration or fees paid to professional appointed by liquidator or other expenses, development in material litigation, filing of or development in the application for avoidance transaction, changes if any in the estimated liquidation cost. Progress report shall enclose an account maintained by the liquidator showing receipts and payments and cumulative amount of receipts and payments since liquidation commencement date. Progress report shall enclose a statement indicating the material change in expected realization of the property to be sold along with the basis of such change. So I need to be very particular with regards to the property which there is an expected change, what I have anticipated as its realizable value, and what is the reasons of such changes in the anticipated value. A progress report shall enclose a statement indicating any material change in expected realization of the property proposed to be sold along with the basis of such change. The progress report for the fourth quarter of the financial year shall include audited accounts of the liquidator receipts and payments. Submission of claim, I'm not referring again. But it is important that if a secured creditor is submitting its claim and if he is intending to realize the security interest, he need to submit its claim and he need to communicate the said fact to the liquidator. Suppose if he want to realize or enforce, he need to intimate. If he is not intimating the said fact, it is always presumed that he is relinquishing the same and the asset shall form a part of the liquidation asset. Here it is very relevant. Proving security interest. Existence of security interest may be proved by secured creditor on the basis of record available in IU. So this can be a basis through which one can, and this is relevant in CIRP also, because in CIRP, this regulation is missing. If I'm the IRP or RP and if I'm getting claim and one is submitting its claim as a secured creditor, I don't have any basis to identify that how one can be treated as a secured creditor. My question to the RP, those who are participating, IPs, those who are participating, to all the IPs or to few of the IPs, I just want to invite your attention to this question, that if I'm filing my claim, I'm one of the secured creditor I'm claiming, but my charge is not registered with the registrar of companies. My charge is not registered with the registrar of companies, but the only registration which is available with me is registration with Sarsai, and that is for the limited purpose for the securitization. and there is no such kind of intimation or submission or reporting with the IU, in what manner my claim is going to be treated? Because what we are dealing is the liquidation regulation, and in the insolvency regulation, this particular thing is missing, that if I'm IRP or if I'm the RP and if I'm getting a claim and one is putting a claim as a secured creditor, but the charge is not registered in his favor, charge though created but not registered with the ROC, and section 77 clearly states that if charge is not registered, it is a void against creditor and void against liquidator. So whether I am going to rely upon what is stated in regulation 21, or I will straight away classify him as an unsecured creditor. This is just a question for the sake of my understanding. My question is, what we are reading is regulation 21 in the liquidation regulation, but there is no such kind of regulation which is pari materia to 21. So my point is, if I'm the IRP or if I'm the RP getting a claim from one of the financial creditor and he's claiming himself or he's claiming itself as a secured creditor, and the charge is not registered with the registrar of companies, in what manner I'm going to treat, whether he will still be considered as a secured creditor or not?
I think it should be considered as secured only
On basis of?
on the basis of documentation of hypothecation or anything like that.
But that is just a creation of charge. If not registered, then
I don't think that is required. Registration is required. Otherwise,
section
also
70, section 77 of the Companies Act is very clear that if the charge is not registered, it is a void against liquidator. I'm not going to consider that head as a secured creditor as far as the language of section 77 is concerned. And why should I refer to section 21 is also one of my question. Views are invited. This kind of sessions are for the sake of interaction, because what I am reading is also read by you multiple times. It's the interaction which can make some difference or can bring some opinions. Because he is providing me the SARSAI registration, but the promoter of the corporate debtor are contesting that intimation or the details which are lodged with the SARSAI registration, because SARSAI registration is just in reporting. What you are reporting is not being authenticated, and there are certain things which are not in line with the facts. Charge is not registered in favor of that secured creditor, which otherwise is required to be registered with the ROC, as also provided in regulation 21 of the liquidation, certificate of registration of charge issued by the ROC. But here the case is, the certificate of registration of charge is not available. SARSAI registration do have its own reason, which is there under SARFASI, so that one can invoke the provisions of that law. And one is the information which is lodged with the IU. In absence of this thing, what I'm going to treat that creditor's claim as? So I may not consider him as a secured creditor if the charge is not registered or there is no other document through which he is demonstrating that why he should be treated as a secured creditor. So if I go by the definition of charge, simply creation of a security interest will serve the purpose. But when I go with the requirement of section 77 of the Companies Act, there is nothing contradictory which is provided in the code. And that's why I would like to say here, section 238 is not going to be a point of discussion that why it should prevail and why it should not. So section 77 of the Companies Act mandatorily states that if the charge is created, has to be registered. If not registered, during the course of CIRP, one is submitting a claim as a secured creditor, I may not entertain this claim as a secured creditor. Proving security interest is a point. The existence of security interest may be proved by a secured creditor on the basis of the records available in IU, if any, certificate of registration of charge issued by the registrar of companies, proof of registration of charge with CERSI, that is Central Registry of Securitization Asset, Reconstruction and Security Interest of India. But it do have its own relevance or a purpose or the object. Presumption of security interest, this is what I was talking about. When being a liquidator, when I invite claim, you have to submit the claim within 30 days from the liquidation commencement date. And when you intimate, when you submit your claim and when you update your claim within 30 days, you need to inform as a secured financial creditor whether you want to relinquish or whether you want to enforce or realize it outside the domain of 53. A secured creditor shall inform the liquidator. A secured creditor shall inform the liquidator of its decision to relinquish the security interest to the liquidation estate or realize its security interest, as the case may be, in Form C or Form D of Schedule 2. Provided that where secured creditor does not intimate its decision within 30 days from the liquidation commencement date, the asset covered under the security interest shall presume to be a part of the liquidation estate. So if informed, I will keep out of the liquidation estate, because then he is going to enforce or realize it separately, and that asset shall not form a part of my liquidation estate. But when he is intimating, this is altogether a different thing. But when I'm not getting any intimation of the decision from a secured creditor within a specified time frame of 30 days from liquidation commencement date, the asset covered under the security interest shall presume to be a part of liquidation estate. Quite relevant. Where a secured creditor proceeds to realize its security interest, it shall pay as much towards the amount payable under clause A and subclause 1 of clause B of subsection 1 of 53, which talks about the liquidation cost or CIRP cost be proportionate amount payable to the workman dues also, as if would have been shared in case it had relinquished the security interest to the liquidator within 90 days from the liquidation commencement date. Excess of the realized value of the asset, which is subject to security interest, over the amount of his claim admitted, he shall pay to the liquidator within 180 days from the liquidation commencement date, provided where the amount payable under this sub-regulation is not certain. By the date the amount is payable under this sub-regulation, the secured creditor shall pay the amount as estimated by liquidator. Why it is not certain? Generally, liquidation cost is not certain because it depends upon up to the length till the liquidation commence or will continue. So in that case, where the amount payable under this sub-regulation is not certain, by the date the amount is payable under this sub-regulation, the secured creditor shall pay the amount as estimated by the liquidator. But one thing is very clear, that if we do not relinquish it, it shall not form a part of the liquidation estate. And in that circumstances, this secured creditor has to pay as much towards the amount payable under clause A and subclause 1 of clause B of subsection 1 of 53, as it would have shared in the case it had relinquished the security interest to liquidator within 90 days from the liquidation commencement date. The excess of realized value of the asset, which is subject to security interest, over the amount of his claim admitted to the liquidator within 180 days from the liquidation commencement date, provided where the amount payable under this sub-regulation is not certain. By the date amount is payable under this sub-regulation, the secured creditor shall pay the amount as estimated by liquidator, provided further that any difference between the amount payable under this sub-regulation and amount paid under the first proviso shall be made good by the secured creditor or liquidator, as the case may be, as soon as the amount payable under this sub-regulation is certain and so informed by the liquidator. Where a secured creditor fails to comply sub-regulation 2, the asset which is subject to security interest shall become a part of the liquidation estate. So this is what provided. Sum and substance of this particular sub-regulation is, if I'm the secured creditor, when liquidator give a public announcement for invitation of claim, or when invite for the updation of the claim, it is something which I need to place it before the liquidator that I would like to relinquish it or I want to enforce it. If I want to enforce it, the asset shall not form a part of the liquidation estate, but this is the pro rata amount which I need to set it aside. Verification of claim. Liquidator shall verify the claim submitted within 30 days from the last date of receipt of the claim. So it is up to 60th day of the liquidation commencement date. Within 30 days, one has to submit the claim, and thereafter, within 30 days from the last date of submission of claim, the liquidator has to verify the same. The liquidator shall verify the claim within 30 days from the last day of receipt of the claim and may either admit or reject the claim in whole or part as the case may be. Liquidator shall verify the claim collated during the CIRP but not submitted during liquidation process within 30 days from the last day of receipt of the claim during liquidation process and may either admit or reject. So it is very clearly stated that if I have submitted my claim during CIRP but I have not submitted my claim during the liquidation, I have not updated my claim, in that case, whatever claim form I have submitted during the course of CIRP, that is going to be referred by the liquidator, and liquidator shall verify the claim collated during CIRP within 30 days from the last day of the receipt of the claim. If I'm not getting any claim from you, but you have submitted your claim during CIRP, I'm going to verify that. List of stakeholder, this is again relevant. Liquidator shall prepare the list of the stakeholder category wise on the basis of the proof of claim submitted and accepted under this regulation, with amount of the claim admitted, extent to which the debt or dues are secured, debt of the stakeholder, proof admitted or rejected in part, proof wholly rejected. Liquidator shall file the list of stakeholder with the adjudicating authority within 45 days from the last day of receipt of claim. So that is within 15 days from the expiry of 30th day. Liquidator shall file the list of stakeholder with the adjudicating authority within 45 days from the last day of receipt of the claim. Liquidator may apply to the adjudicating authority to modify an entry in the list of stakeholder filed with the adjudicating authority when he comes across additional information warranting such modification. Liquidator shall modify an entry in the list of stakeholder filed with the adjudicating authority in the manner as directed by the adjudicating authority while disposing of an appeal. So this appeal generally preferable within 14 days. If I need to intimate, being a liquidator, I need to intimate whether I'm admitting or whether I'm rejecting or whether I'm partly admitting or partly rejecting your claim. If I'm rejecting or partly rejecting anyone's claim, then in that case, appeal is required to be preferred before the adjudicating authority under section 42 of the code. The list of stakeholder as modified from time to time shall be available for the inspection by the person who submitted the claim, available for the inspection by members partner or designated partner or guarantor, displayed on the website of the CD, filed on the electronic platform of the board. Stakeholder consultation committee, it is something which is crucial. This is very important, whatever stated. The committee of creditor under section 21 COC, what we used to form, shall function as a consultation committee with the same voting right till constitution of the committee take place under subregulation 1. The liquidator shall constitute a consultation committee comprised of all the creditor of the CD within 60 days from the liquidation commencement date based on the list of stakeholder prepared under regulation 131 and to advise them on the matter relating to remuneration, sell until 32 including manner of sell, pre-bid qualification, reserve price, fees of liquidator, valuation under subregulation 2 of 35. This is when already CIRP में valuation करवा रखा था, but during the course of liquidation अगर valuation करवाना है तो again stakeholder consultation committee's consent is mandatory. The manner in which the proceeding in respect of preferential, undervalued, extraordinate credit transaction or fraudulent or wrongful transaction, if any, shall be pursued after the closure of liquidation proceedings, and the manner in which the proceeds, if any, from this proceeding shall be distributed. Review of marketing strategy in case of failure of sale of the CD as going concern. continuation or institution of any suits or legal proceedings, extension of payment of the balance sale consideration. So these are the agendas, or these are the items for which consultation committee need to be consulted. The voting share of the member, anyways, let's not go into it. Provided that a secured creditor who has not relinquished its security interest, in order to be a part of the stakeholder consultation committee, the secured creditor has to relinquish the security interest. After relinquishing the security interest, one can be a part of the the stakeholder consultation committee. Otherwise, if a person is enforcing on realizing the security interest, in that case, the asset shall not form a part of the liquidation asset, neither he shall be considered as a part of the stakeholder consultation committee. Sell of asset. This is quite important. The liquidator may sell the asset on standalone basis, but the first attempt cannot be this. In slum sell, first attempt cannot be this. Set of asset collectively, assets in parcel in bits and pieces. Corporate debtor as a going concern. This is something to explore first. That is E. Regulation 32E. This is first to explore. Corporate debtor as a going concern, or business of the corporate debtor as a going concern. Where there is an asset which is subject to security interest, it shall not sold under any of the clauses of A to F unless the security interest therein has been relinquished to the liquidation estate. This is important. Where an asset is subject to security interest, it shall not be sold under any of the clause of A to F unless the security interest there has been relinquished the security interest. If it is not relinquished, you cannot sell in this manner. Especially the asset which is subject to security interest. So the liquidator may sell the asset on standalone basis. Slum sale is possible. Sell of the asset collectively. Sell of the assets individually, that is in parcel or in bits or in pieces. Corporate debtor as a going concern, or business of the corporate debtor as a going concern. Business as a whole. This is something which is very difficult to differentiate. Corporate debtor as a going concern and business of the corporate debtor as a going concern. Where there is an asset which is subject to security interest, it shall not be sold under A to F unless security interest therein has been relinquished to the liquidation estate. This is very important. 32A, sell as a going concern, and this is what I was talking about. The liquidator may sell the assets of the corporate debtor under clause E, that is sell as a going concern, of regulation 32 exclusively only at the first E auction. And this explanation is provided for the purpose of this sub-regulation. It is hereby clarified that the sale of the corporate debtor under clause E of 32 cannot be offered only option for the bidder after the first auction, but first auction should be to sell the corporate debtor as a going concern. Where the committee of creditor has recommended sell under clause E or F of regulation 32, or where the liquidator is of the opinion that sell under E or F of 32 shall maximize the value of CD, he shall endeavor to first sell under the said clauses, E or F. For the purpose of sell under sub-regulation 1, the group of asset and liability of the CD has identified the committee of creditor, which is constituted as identify the committee of creditor. This is, I'm talking about that committee which has decided that not to approve the plan, or in absence of the plan, when committee decide to go for a liquidation, they used to decide the group of asset and liability of the CD has identified the COC which are to be sold as a going concern. Where the committee of creditor has not identified the asset and liability under sub-regulation 2 of regulation 39C, the liquidator shall identify the group of asset and liability to be sold as a going concern in consultation with the consultation committee. And this is what I was talking about. The liquidator must sell the CD as a going concern under clause E exclusively only at the first option. So in case of first auction, attempts will be made to sell the corporate debtor as a going concern only at the first auction. And clarification in this connection is provided. For the purpose of this sub-regulation, it is hereby clarified that the sale of the corporate debtor under clause E of regulation 32 cannot be offered as the only option for bidders after the first auction. But first auction के लिए the sub-regulation 4 of 32A is important. The liquidator may sell the asset of the CD under clause E of regulation 32 exclusively only at the first auction. But it is clarified through an explanation that for the purpose of sub-regulation, it is clarified that the sale of the corporate debtor under clause E of 32 cannot be offered as the only option for the bidder after the first auction. But for the first auction, it is only option which is available for the bidders. Where the liquidator is of the opinion that it is viable to run the corporate debtor as a going concern, he shall consult the consultation committee, and only on its advice he shall run the affairs of the CD as a going concern. Mode of sale regulation 33, which states that liquidator shall ordinarily sell the asset of the corporate debtor through an auction in manner specified in Schedule 1 of this regulation. But it is not hard and fast that it should be sold liquidator shall ordinarily sell the asset of the corporate debtor through an auction, but it is not hard and fast that he need to opt for this auction only. He can go for a private sale also. Liquidator may sell the asset of the corporate debtor by means of private sale only after the prior consultation with the consultation committee in a manner specified in Schedule 1 when asset is perishable or asset is likely to deteriorate in value significantly if not sold immediately. Prior permission of the adjudicating authority has been obtained for such sale. Provided that the liquidator shall not sell the asset without prior permission of the adjudicating authority by the way of private sale to related party of the CD or related party of the liquidator or any professional appointed by him. So this is very clear that liquidator shall not sell the asset without prior permission of the NCLT by way of private sale too. So there is no prohibition, but it says that the approval of the adjudicating authority is required if you are intending for a private sale to a related party of the CD or to the related party of the liquidator or professional appointed by him. Liquidator shall not proceed with the sale of the asset. Now this is quite important. Again, you cannot sell to the person who is not eligible under 29A. The liquidator shall not proceed with the sale of the asset if he has reason to believe that there is a collusion between the buyers or the corporate debtors related party and the buyers, or the creditor and the buyer, and shall submit a report to the adjudicating authority in this regard, seeking appropriate order against the colluding parties. Asset memorandum, this is important. Asset memorandum, I'm going to take care of from the information memorandum, that whatever is the available asset of the corporate debtor as per the information memorandum prepared by the RP, I will be taking that into consideration while preparing the asset memorandum. For the cases under sub-regulation 1 of 35, the liquidator shall within 30 days from the liquidation commencement date prepare an asset memorandum in accordance with this regulation based on the information memorandum prepared under 29. And for the asset covered under regulation 2 of 35, wherein I will be opting for another liquidation or I will be opting for another valuation during the course of liquidation. First is regulation 35.1, which talks about the liquidation value which was derived during the course of CIRP. And 35.2, which talks about opting for valuation again when corporate debtor goes into liquidation, because many times it happens ample of time and ample of months and years have been elapsed from the date. If we compare from the date when company was in CIRP and the date when company was dragged in the liquidation, and asset, the valuation of asset is subject to its further valuation. So the cases which are sub-regulation, for cases under sub-regulation 1 of 35, wherein I'm relying upon the valuation which I have derived or the RP has derived during the course of CIRP, the liquidator shall within 30 days from the liquidation commencement date prepare an asset memorandum in accordance with this regulation based on the information memorandum prepared under 29 with suitable modifications. And for the cases covered under regulation 2 of 35, the liquidator shall prepare the asset memorandum in accordance with this regulation within 75 days from the liquidation commencement date. Asset memorandum shall provide the following details in respect of the asset which are intended to be realized by the way of sale. Value of the asset or business under clause B to F of regulation 32, valued in accordance with regulation 35 if intended to be sold under those clauses, intended manner of sale in accordance with regulation 32, intended mode of sale, expected amount of realization, any other information as may be relevant. The asset memorandum shall provide the following detail in respect of each of the asset other than those referred in sub-regulation 2. Value, intended manner and mode of realization, expected amount, any other information. Liquidator shall file asset memorandum along with the preliminary report, which is again required to be filed within 75 days. This is what I was talking about, valuation. As far as the valuation is concerned, the valuation has been conducted under regulation 35 of the Insolvency Bankruptcy Board of India insolvency resolution process for corporate persons. So at the time when CIRP, at the time when RP was appointed, within 7 days, he has opted for a liquidation, both fair value and the liquidation value. Other than that, if the cases is not covered under sub-regulation 1 and where the liquidator, after the consultation with the consultation committee, is the opinion that the fresh valuation is required under the circumstances, he shall within 7 days from the liquidation commencement date appoint 2 registered valuer to determine the realizable value of the asset or business under clause A to F of regulation 32. Asset sale report. On sale of an asset, the liquidator shall prepare asset sale report in respect to the asset which is enclosed with the progress report, which have to be filed on quarterly basis within 15 days. Realized value, cost of realization, the manner and mode of sale. Value realized is less than the value which is mentioned in the asset memorandum. Reasons towards the same, person to whom the sale is made, or other detail. So I have to mention that during the course of this quarter, for which I am submitting my report, the progress report, I have to mention the realizable value, cost of realization, manner and the mode of sale. Value realized is less than the value in the asset memorandum. The person to whom the sale is made. Now, this is very important, what we were discussing in section 52 and just few minutes before. A secured creditor to have both the options available, either to relinquish or to enforce. A secured creditor who realizes its security interest under 52. A secured creditor who seeks to realize the security interest under 52 shall intimate the liquidator the price at which. Now, this is something which is required to be understood, that if I'm the one who is intending to realize the secured asset which was created in my favor, I have to inform to the liquidator. So there is no timeliness which is prescribed in regulation 37, but why it is crucial? When within 5 days from the liquidation commencement date, when liquidator invites a claims for or claims to be submitted, when he gives a public announcement for the sake of invitation of the claim or for the sake of updation of the claim, the creditor, as a secured creditor, I have to intimate that I want to relinquish it or I want to realize it. If I want to realize it, I have to intimate the liquidator of the fact, the price at which I want to realize. Secured creditor who seeks to realize the security interest under 52 shall intimate the liquidator of the price at which he proposed to realize the security interest. Second, that is regulation 37 sub-regulation 2. Liquidator shall inform the secured creditor within 21 days of the receipt of intimation. So when the secured financial creditor is intimating the same, I shall inform the secured creditor within 21 days of the receipt of intimation. If I do have a person who is willing to buy the secured asset before the expiry of 30 days from the date of intimation at a price higher than the price intimated to me by the secured creditor under sub-regulation 1. Now see, the secured creditor is intimating the liquidator under regulation 37(1), who is intimating that he want to realize the security interest under 52, and he's intimating me about the price at which he proposed to realize the same. He's intimating me and I'm intimating him further. Within 21 days from the receipt of the intimation, if there is a person available with me, liquidator, who is willing to buy the secured asset before the expiry of 30 days from the date of intimation under 1 at a price higher than the price intimated by the secured financial creditor under subregulation 1, where the liquidator informed the secured creditor of a willing purchaser, willing buyer to buy the secured asset under subregulation 2, the secured creditor shall sell the asset to such person. And if the liquidator does not inform the secured creditor in accordance with subregulation 2, or the person about which the liquidator has informed that he wanted to purchase at a price higher than the price which you are tendering, if a person does not buy the secured asset in accordance with subregulation 2, the secured creditor may realize the secured asset in a manner as it deemed fit, but at least at a price intimated by him under subregulation 1. The secured asset is realized if the secured asset is realized as per subregulation 3, the secured creditor shall bear the cost because it was a liquidator who found that person. If the secured asset is realized under subregulation 4, the liquidator shall bear the cost incurred to identify the buyer. But this everything shall not be applicable if the realization take place under surface, meaning thereby even during the course of liquidation, realization may take place under surface. The provision of this regulation shall not apply if the secured creditor enforce its security interest under surface or under the Recovery of Debt and Bankruptcy Act, RDB Act. Secured creditor shall not sell or transfer an asset which is subject to security interest to a person who is not eligible under the code to submit a plan, that is 29A. This is the last but not the least thing, distribution, and here we will be dealing with section 53. Subject to the provision of 53, the liquidator shall not commence distribution before the list of stakeholder and asset memorandum has been filed with the adjudicating authority. List of stakeholder, that is within 45 days. Asset memorandum, what we have seen along with the preliminary report. Liquidator shall distribute the proceeds from realization within 90 days from the receipt of the amount. Insolvency resolution process cost and liquidation cost shall be deducted. And this is again completion time frame, which is word used as endeavor. Liquidator shall liquidate the corporate debtor within a period of 1 year from the liquidation commencement date, notwithstanding pendency of any application of avoidance transaction. But if the liquidator fails to liquidate the corporate debtor within 1 year, he shall make an application to adjudicating authority to continue liquidation, along with a report explaining why the liquidation has not been completed, specifying the additional time that shall be required for liquidation. The liquidator shall, on the advice of consultation committee provided in the application filed along with the final report under regulation 45, for the manner in which the proceeding in respect of avoidance transaction or fraudulent transaction will be pursued after the dissolution or closure of the liquidation proceeds, and manner in which the proceeds, if any, from. So at the time when you move a dissolution application, you need to mention the manner in which the applications are going to be treated, or the applications are going to be managed, or application are going to be taken care of after the dissolution of the CD. So liquidator, on the advice of the consultation committee, provide in the application along with its final report filed under regulation 45 the manner in which the proceeding in respect of avoidance transaction, if any, fraudulent or wrongful transaction, will be pursued after the dissolution or closure of the liquidation process, and manner in which the proceeds, if any, from the proceeding shall be distributed. Final report. When corporate debtor is liquidated, the liquidator shall make an account of the liquidation showing how it is concluded and how the corporate debtor assets have been liquidated. If the liquidation cost exceeds the estimated liquidation cost provided in the preliminary report, liquidator shall explain the reasons for the same. Liquidator shall submit an application with final report and the compliance certificate in Form H for the closure of liquidation process of the CD, where CD is sold as a going concern, or for dissolution of the CD in case if it is not covered under Clause A. So I think as far as this discussion is concerned, it was relevant, because now when we will be dealing with 53 and the ongoing burning issues with regards to 53, probably this reading is going to help us out. If there is something to take care of, we will be taking care of that thing first. Otherwise, I just want a request to have a 10 minutes break before we start with the ongoing issues pertaining to the liquidator which he used to face during the course of liquidation and distribution process. If some areas to be focused upon, if something to be taken care of, we should take that first into consideration before taking a break. Otherwise, I just want a break of 10 minutes. We'll be back at 5 and we will be dealing into the aspects of the ongoing litigations before the forum, before the adjudicating authority or the appellate authority, or before the Honorable Apex Court. Maybe proceed. There's a final phase wherein I would like to have certain things which are always deliberated upon, or are the contested facts before the tribunal or the appellate tribunal or by full Supreme Court, some unsettled laws, some ambiguity, some burning issues, some very relevant or vital issues as far as the liquidation is concerned or as far as the waterfall mechanism is concerned. We are going to take care of each one. We'll be taking care of certain decided case laws, the contradictory or the contradiction between two judgments by the same forum. This is what we need to take care of as far as section 53 is concerned, which deals with the waterfall mechanism. But what is the ambiguity in this 53 that can be identified out of the content which I'm sharing? And this is just an opinion, or these are the content of various authors, or this is something which one can identify or one can face as a liquidator. This is the first one is pertaining to dues such as PF, gratuity, and ESIC. It very clearly stated that this shall not form a part of the liquidation estate. When this shall not form a part of the liquidation estate, now the question is how a liquidator will be in a position to dealt with this, especially in a case when the corporate debtor has not contributed the amount which otherwise was required to be contributed as a dues towards PF, gratuity, or ESIC. That is one of the subject matter we are going to deal with. Apart from that, the second important aspect is government dues under IBC. That is after the rainbow paper judgment. That is going to be taken care of. Apart from this, inter se priority among secured creditor in liquidation. Because what we are learning or what we are delivering or what we are understanding out of the discussion of 52 and 53 is, if I'm a secured creditor and relinquishing the security interest, then irrespective whether a charge is created in my favor as a first pari passu charge or whether I'm a second pari passu charge holder, we all will be treated as a one class and as a secured creditors. There will be no further division within the said category of the secured creditor. So this is the inter se priority among the secured creditor that is going to be taken care of. And the fourth one, which I was talking about, that section 52 do have its relevance, 53 do have its relevance even during the course of CIRP when the resolution plan is placed before the committee of creditors for its approval. So that is one of the aspect that 53 is relevant from the viewpoint of the assenting financial creditors and dissenting financial creditor. A dissenting financial creditor should get at least an amount which otherwise is distributed to them during the course of liquidation. So that is something which we need to take care of. These are the four aspects which I would like to have with you. And to start with is the government dues. Dues such as the PF, gratuity, and ESIC. Employee dues is a crucial aspect in the operations of the company, though IBC gives a second order of priority. Employee dues is a crucial aspect in the operations of the company, though IBC gives second order of the priority to the employees' dues. In waterfall mechanism, there seems to exist some loopholes in terms of employee social security such as PF, gratuity, and pension. In liquidation vis-a-vis, the NCLT has given contradictory judgment in some of the cases in Lanco Infratech and Moserware. Liquidation process itself need to be completed within 1 year, and hence there often the liquidator may face challenges with respect to dealing with the statutory dues such as PF, gratuity, ESIC, and often has to deal with the attachment of any of the property or asset of the CD by the government agencies such as EPFO, pending payment of the full dues by the liquidator where the is in dilemma in dealing with this issue. So this is something which we are going to take care of. Now, one of the foremost thing to take care of is section 36 subsection 4 clause A. As far as the this section 36 is concerned, section 36 deals with the liquidation estate. Liquidation asset or the liquidation estate is inclusive of all the asset of the corporate debtor. Section 36 of the IBC specifically excludes certain assets which are not forming a part of the liquidation estate and shall not be used for recovery in liquidation, specially exclude all the sum due to workman or employee from provident fund, the pension fund, gratuity fund. The dilemma for the liquidator here is that there is a legal fiction contained in 36(4)(a)(3), which specifically provides for exclusion of the asset owned by third party. And further, section 36(4)(a)(3) specifically provides that the provident fund, pension fund, gratuity fund are excluded from the liquidation estate because these are not considered as the asset of the corporate debtor. Where the CD has not specifically provided the fund to PF gratuity, then it is further complications for the liquidator as EPF or gratuity does not fall under the waterfall mechanism under 53 IBC. As far as section 36(4)(a)(3) of the code exclude all sum due to workman or employee from provident fund, pension fund, gratuity fund from liquidation estate of the corporate debtor, thereby excluding the same from the purview of the waterfall mechanism as enriched under 53 of the code, which enumerates the order of priority in which the claims have to be settled against the asset of the corporate debtor, but the amount which is lying in this fund shall not form a part of the liquidation estate, and this will not be made available for the distribution among the stakeholder as hierarchy provided under 53. EPF claim raised against the asset of the CD are often opposed by the liquidator or the successful applicant by largely relying upon the term workman dues under 53(b)(2) of the code, which does not cover the EPF claim. The current judicial trend in treating EPF dues under the provision of EPF Act and Code is highly characterized by the judicial protectionism towards the employee, which is in line with the legislative intent behind the explicit exclusion of EPS dues under 36(4)(a)(2). This position of law with regards to explicit exclusion of EPF dues from liquidation estate has now been endorsed and concentrized by the apex court Sunil Kumar Jain versus Sundarsh Bhatt by expressly stating that section 36(4) of the code has clearly given outright protection to the workman dues under provident fund, gratuity fund, and pension fund, which are not to be treated as a liquidation estate, and the liquidator shall have no claim over such dues. Now, when you see this Alchemist versus Moser Bear India Private Limited, it was the NCLT which has held that even if there is a deficiency in the pensions fund, provident fund, or gratuity fund, the liquidator has to ensure that the fund are created and distributed to the workmen outside 53 waterfall. In this judgment, the tribunal held that liquidator must provide for this fund even if there was no diversion of fund by the CD. This is quite complex. In this judgment, the tribunal held that liquidator to provide this fund even if there was no provision of such fund by the CD. Tribunal has held that overriding effect of 238 of the code over other law for the timing in force will not have any bearing over the asset of the workmen relating to PF, pension fund, and gratuity lying in possession of the CD because the asset is not considered as a part of the liquidation asset. And that's why there is no contradiction between this code and this PF Act or the Act deal with the pension fund and gratuity. This order was impugned by the financial creditor, that is SBI, a secured creditor of the Moser Bear in SBI versus Moser Bear Karmchari Union, wherein the limited question before the enclave was whether the gratuity dues forming a part of the liquidation estate, NCLT in this case decided not to interfere with the order of NCLT, and NCLT has passed an order that fund should be created and distributed to the workmen outside the purview of 53, even though the no provision has been or no provisioning has been made by the corporate debtor. Further, in the case of Precision Fasteners Limited versus EPF, the liquidator appealed against the attachment of the property by EPFO and prayed for treating them in null and void. NCLT Mumbai bench vacated the attachment but held that the entire arrears towards EPF should be paid before paying of the other creditors. In some of the judicial pronouncement, the judiciary used the term right to life when it considered the workers' dues such as PF, gratuity, and pension fund, which are take precedence over the other dues. In Precision Fasteners Limited versus EPFO case, in Precision Fasteners versus EPFO case, the NCLT Mumbai held that right of all the other creditor over the asset of the company is a proprietary right, whereas the workmen dues, more specifically PF dues of workmen, are interwoven right to life. The workmen, although their life save some portion of their hard and earning for their later life after retirement, and they could not be treated on par with the other creditor who have a proprietary right. Reiterating the importance of the PF dues, the NCLT Chennai bench in the case of Assistant Provident Fund Commissioner and Recovery Officer EPFO versus Florent Shoes Private Limited and other held that the liquidator can sell the asset of the CD as stated under IBC and first pay off the dues payable to applicant before distributing the asset as stated under 52 and 53 of the code. So this is what it is provided, that it shall not or it shall never be considered as a liquidation estate. And if the provision was not made by the corporate debtor, then the RA should take care of this fact, or the liquidator should take care of this fact. And this is what provided in this Assistant Provident Fund Commissioner and Recovery Officer EPFO versus Florent Shoes Private Limited and another held that the liquidator can sell the asset of the CD as stated under IBC and first pay off the dues payable to the applicant before distributing the asset as stated under 52 or 3 of the code. In the matter of UCO Bank Asset Management Recovery Branch versus Recovery Officer, the recovery officer EPFO attached the immovable property belonging to the Pondicherry Textile Corporation Limited, against which the insolvency resolution process was initiated on later date. During the pendency of the CIRP, the recovery officer EPF proposed to sell off the property attached by him. Auction sale of the property was contested by the UCO Bank. Division bench concluded what is sought to be recovered by the petitioner bank from respondent to is its debt, which are included in section 11.2 of the EPF Act. Therefore, there is no hesitation in holding that EPFO was well within its power to issue order of attachment. Now, this all are the favorable orders in favor of the fact that the liquidator should consider that amount which is there in PF or gratuity or pension fund as a part of the amount for which a sole beneficiaries are going to be the workmen. In the matter of Standard Chartered Bank versus JVL Agro Industries, NCLT Ahmedabad, the directed liquidator to procure a new gratuity policy for 403 employee whose premium were not paid by CD to the insurance fund created by the CD. NCLT directed the liquidator to procure a new gratuity policy for 403 employee whose premium were not paid by the CD, to the insurance fund created by the CD. Contradictory pronouncement, and this is what you will find. A contradictory view has been taken in case of Regional Provident Fund Commissioner versus Karpagam Spinners Private Limited. It was held by the enclave that pursuant to 238 of the IBC, it will override anything inconsistent with the code, including EPF Act, and the workmen dues as payable under the EPF Act will not be considered in priority to the priority of payment under 53. Now, this is quite contradictory. However, in the matter of Savan Godiwala, liquidator of Lanco Infratech versus Apala Siva Kumar, the appellate tribunal, the liquidator submitted that there is no separate fund for gratuity payment. Same cannot be done from the running account of the CD. Enclave in this case held among other consideration, including judicial precedent in Moser Bear case, refer to section 36.2 of the IBC to reason that liquidator hold fund in the liquidation estate in a fiduciary capacity for the purpose of distribution among the creditor in terms of 53 of the IBC. However, held that in case where no fund is created by the company in violation of the statutory provision of section 4 of Payment of Gratuity Act, then in situation the liquidator cannot be directed to make the payment of gratuity to employee because the liquidator has no domain to deal with the property of the CD which are not a part of the liquidation estate. This is quite contradictory. I'm talking about this fact wherein it is stated that liquidator, this is the enclave which states that liquidator cannot be directed to make the payment of gratuity to employee because the liquidator has no domain to deal with the property of the CD which are not forming a part of liquidation estate. And since it is not forming a part of the liquidation estate, liquidator cannot deal with such a set. Contradiction in the NCLT pronouncement between Lanco Infratech and Moser Baer. In Lanco case, Moser Baer is something which is aware, enclad by order held that PF dues, pension funds, and gratuity do not form a part of the liquidation estate and cannot be a part of 53. But enclad said liquidator cannot avoid the liability to pay gratuity dues to the employee on the premise that no separate fund was created by CD. Whereas in Lanco Infratech case, NCLT directed liquidator to pay gratuity dues to the employee even when CD has not created the separate dues of the fund and held that gratuity fund do not form a part of the liquidation estate even when no specific fund was created by CD. Enclad, while hearing the appeal, held that where there are no specific fund created for gratuity, liquidator should not have been directed to make the payment of gratuity as per a worker's entitlement. Enclad in its judgment specifically held that it is not the liability of liquidator if no fund were created by CD, and thus there is a contradiction from Moser Baer judgment. Here also this is important. Tourism Finance Corporation of India versus Rainbow Papers. I'm not talking about the Celtics. RP stated that the approved resolution plan has duly taken care of all the statutory dues and the principal amount of PF has been taken into consideration. In contrast, the order of levying of interest by PF authorities after commencement of CIRP is not permissible under the law. He further claimed that provision contained in 7Q and 14B of the EPFMP Act cannot be relied upon as the provision of IBC have an overriding effect on the same in terms of 238, but Enclad Delhi held that RP to release full amount of PF including interest thereon in terms of the provision of EPFMP Act immediately as the dues are not included in there. So basically there is a contradictory views with regards to treatment of the amount which is payable towards the employer's contribution to the PF. No conflict between the code and EPF Act. So this is the Tourism Corporation of India versus Rainbow Papers. It clearly states that one of the major argument often put by the liquidator or successful resolution applicant for application of IBC versus vis-a-vis the provision of EPF Act is the overriding effect of the code as provided in 238 of the code. However, the enclad in Tourism Finance Corporation versus Rainbow Paper has explicitly held that since no provision of the code and EPF Act are in conflict, the application of 238 of the code does not arise. The apex court concurred with the reasoning set out by enclad and refrained from interfering with the judgment, ultimately dismissing the appeal. Therefore, as provision of IBC do not override EPF Act, it became pertinent to note that relevance of 17B of the EPF Act. 17B of the EPF Act creates an obligation on the transferee to pay the contribution and other sum due from the employer when an establishment is transferred. Therefore, by operation of 17B of EPF Act, the successful resolution applicant is made liable to pay the provident fund which the corporate debtor owes to employee. This is 17B versus 238 because 17B and 53 are not in contrary to each other. And that's why it is stated that the provisions of the code and the effect of EPF Act. It is pertinent to note that relevance of 17B of the EPF Act, which states that there is an obligation on transferee to pay the contribution and other sum due from employer when established is transferred. And when establishment is transferred, it is an obligation on the transferee. Therefore, by operation of 17B of EPF Act, the successful applicant is made liable to pay the PF which the corporate debtor owes to its employee. While it is justifiable that right to life is a crucial fact to be considered by liquidator while dealing with the distribution of dues to the workmen, for 36(4)(a)(3) rightfully protect the dues of worker even when CD has not provided for PF and gratuity. And last one before we deal into the another one, and this is the Jet Aircraft Maintenance Engineers Welfare Association versus Ashish Chavcharia. This is a harmonious construction of 36 and 18. This is very excellently stated or mentioned. The code is single consolidated law which provides both the options to the creditor, that is corporate insolvency resolution or liquidation, to successfully recover the dues from the corporate debtor. Interestingly, section 18F of the code allow an IRP or the RP to take control and custody of the asset over which the CD has ownership right. However, explanation to section 18 of the code provides for some exception which do not fall under the scope of the term asset of the CD. One of them being the asset owned by third party. And EPF dues are nothing but the asset of the employees lying in possession of the CD. This is section 18 of the IBC, wherein the IRP takes a control and a custody of the asset over which the CD has ownership right. Explanation to 18 of the code provides for some exception which do not fall under the scope of asset of the CD, and one of them being asset owned by third party. And EPF dues are nothing but the asset of the employee lying in the possession of the CD. The judiciary has in unison endorsed the view that EPF dues are asset of the employee, which are in possession of CD, and therefore the same has been carved out of the liquidation estate under 36 of the code. That's why it's not considered as a part of the liquidation estate. While extending the same reasoning to section 18 of the code with respect to CIRP, it is rightly deduced that the IRP cannot deal with the EPF dues owed to the employee even during CIRP. In jet aircraft, the professional RP of Jet Airways, the Honorable Anklet harmoniously construed section 36 and 18 of the code to conclude that EPF dues do not fall under the scope of asset even during CIRP and therefore the IRP cannot alienate or transfer such asset. Anklet observed that the fund, that is provident fund, pension fund, gratuity fund maintained by the CD have to be utilized fully for the payment of the provident fund, pension fund, gratuity fund of the workmen and the employees, and thus this asset cannot included in the information memorandum as the asset of the CD while inviting the resolution plan. So this is something which is again a topic of discussion apart from what we have in the rainbow. This rainbow judgment is exception and this will remain as an exception because now the amendment is taking place in all the other laws which are having a similar language. Rainbow Papers judgment, that is a cell tax officer versus Rainbow Papers. Supreme Court dealt with the question as to whether the provision of the IBC override 48 of the Gujarat Value Added Tax 2003, which the language of the law, section 48 of the GVAT Act, provide as follows: tax to be the first charge on the property, notwithstanding anything to the contrary contained in any law for the timing in force. And it is not provided that save as provided in the IBC. Notwithstanding anything to the contrary contained in any law for the timing in force, any amount payable by a dealer or any other person on account of tax, interest or penalty for which he is liable to pay to the government shall be first charged on the property of such a dealer or as the case may be such person. Now, this was the language of section 48 of GVAT Act. Notwithstanding anything to the contrary contained in any law for the timing in force, any amount payable by a dealer or any other person on account of tax, interest or penalty for which he is liable to pay to the government shall be first charged on the property of such dealer or as the case may be such person. It was held, the Honorable Supreme Court, 48 of GVAT Act is not contrary to or inconsistent with 53 or any other provision of the code. Under 53(1)(b)(2), That is what we deal with, a secured creditor, which will be ranking parallelly with the government, ranking parallelly with the workman dues of preceding 24 months prior to the date of liquidation commencement date. That debt owed to a secured creditor, which would include the state government under the GVAT Act, are to rank equally with the other specified debt, including debt on account of the workman dues for a period of 24 months preceding the liquidation commencement date. It was the Honorable Supreme Court which has held that the Section 48 of GVAT Act is not contrary, not inconsistent with 53 or any other provision of the code. Under 53 1B2, the debt owed to a secured creditor, which would include a state government under GVAT Act, are to rank equally with the other specified debt, including debt on account of workman dues for a period of 24 months prior to the liquidation commencement date. Supreme Court has held that state is a secured creditor under GVAT Act. Section 3, subsection 30 of the IBC defines secured creditor to mean a creditor in whose favor security interest is created, here by the operation of law. Such security interest could be created by operation of law. The definition of secured creditor IBC does not exclude government dues or government authority. If the plan excludes statutory dues payable to government authority or legal authority altogether, the NCLT is bound to reject such plan. And COC, which might include a financial institution and other financial creditor, cannot secure their dues at the cost of statutory dues owed to government or government authority. So this is what Supreme Court has held. But thereafter, result in departure from the objective of the code. That is the preamble what we have studied. Change in the order of priority. The treatment of dues owed to government or statutory authorities as secured creditor was seen as a departure from the objective or the preamble of the code itself. This is what I was talking about. In January 23, the MCA had put up certain proposed changes to IBC for public comments. One of the proposal was to neutralize the disruptive effect of rainbow papers by introducing an amendment to provide that all debt owed to government or statutory authority will be treated at par with the unsecured creditor, irrespective of any statutory provision creating first charge. But this is the exception which was proposed, except in a case where a security interest has been created in favor of government pursuant to a transaction between it and borrower. So there is nothing like operation of law. It is by the act of parties if it is created. Again, it is important to read. In January 23, the MCA had put up certain proposed changes to the code for public comments in order to neutralize the disruptive effect of rainbow by introducing an amendment to provide that all dues owed to the government or statutory authority will be treated at par with other unsecured creditor, irrespective of any statutory provision creating first charge, except in a case where the security interest has been created in favor of government pursuant to a transaction between it and borrower. Certain judgment dealing with applicability of rainbow papers arising under other statute. And this is what things will be clarified, that why the statutory dues should not be ranking equally with the other secured creditor. Rainbow papers saw an increase in demand from various authorities to be given the same treatment, resulting in delays in approval and implementation of the plan. The adjudicating authority were also examining whether the resolution plan is in compliance with the rainbow papers or not. But this is what we can see from the NCLET in Department of Cell Tax versus Ashish Chhavcharia, being RPO of Jet Airways, dealing with the same issue with the Department of State Tax to be treated as a secured creditor for the purpose of IBC pursuant to provision of 82 of Maharashtra GST Act. When you see the language of Maharashtra GST Act, section 82, you can find otherwise provided in the IBC, notwithstanding anything to the contrary contained in any law for the time in force, save as otherwise provided in the IBC. Save as otherwise provided in the IBC. An amount payable by a taxable person or other person on account of tax, interest, or penalty, which is liable to pay to the government, shall be first charged on the property of such taxable person or such person. But this is what stated in the law, This is same as otherwise provided in the IBC. Here the IBC will have a rule. And that's why in this case, the Department of State Tax cannot be treated as a secured creditor. Placing reliance on Sundarsh Bhatt, liquidator of ABG Shipyards versus Central Board of Indirect Tax and Custom, NCLED held that the provision of 82 of Maharashtra GST Act contain an exception with regards to IBC, and therefore, on the strength of the dues under the Maharashtra GST Act, no charge can be claimed on the asset of the CD. In our view, NCLED correctly held that the rainbow papers will not be applicable to the dues under Maharashtra GST Act in views of specific exclusion of IBC under Section 82. Going by the same analogy, the reasoning of rainbow paper will not be applicable to other statute. And that is what the conclusion is. Rainbow paper will not support the argument that government dues will be secured dues under all circumstances. Basis the Supreme Court view in rainbow paper, the classification of government dues will have to be undertaken in two-pronged manner as follows. First is examination of the provisions of the government legislation, both central and state, to ascertain whether or not the charges created in favor of relevant government and authority in respect of their claim, whether it is created, whether a transaction is there or not. The things are not about operation of law, whether there is an act of parties or not. Whether or not the provision of such governing legislation are expressly made subject to IBC or have a provision pursuant to which IBC given primacy. So this is again very important, whether or not the provision of such governing legislation are expressly made subject to IBC or have a provision pursuant to which IBC is given primacy. If the concerned government legislation create a charge which is not subject to IBC, as the case in the relevant statute which was subject matter in Jet Airways, then such statutory authority will have to be classified as a secured creditor for the purpose of 53, and accordingly it will be eligible for distribution under 53 1B2 of the IBC. Only when, if the government legislation create a charge and is not subject to IBC. Going by aforesaid, it may be noted that dues owed to custom authorities by virtue of 142A of the Custom Act as amended, as well as GST authority by virtue of 82 of the CGST, Central Goods and Service Act 2017 as amended, will not have first charge as the respective provision have been specifically made subject to IBC. It may also be noted that Income Tax Act 1961 as amended does not have any provision for creation of first charge. It has been upheld by NCLED in Jet Airways case. In any event, as discussed above, the decision of rainbow paper has limited application. It is incorrect to rely upon rainbow paper to contend that all government dues are secured dues. Rainbow papers does not lay down the government department or authorities will automatically have the status of secured creditor for the purpose of code. The said position depends on the language and the intent of underlying legislation which regulates the relevant government dues. This is the rainbow. The first one was with regards to the dues pertaining to the employees with regards to the provident fund or pension fund or gratuity fund. The third one, which is again a subject matter of deliberation, is the inter se priority among secured creditor in liquidation. And this is what we are reading time and again, that if I, being a secured creditor, relinquishing the security interest, then I will lose that stage where I was first pari passu charge holder or subsequent pari passu charge holder. The reason is, once I relinquish, I will be treated parallelly with the other secured creditor. But if I enforce, if I realize, then I can always avail the benefit of being the first charge holder or first pari passu charge holder. I'm not going through the meaning of charge, but we are dealing with the judicial interpretation. 53 of the code lays down the waterfall mechanism with respect to payment of debt to the creditor of the corporate debtor. The workman dues and the debt of the secured creditor ranking pari passu under 53. However, the code does not expressly provide for preservation of inter se priority between secured creditor at the time of distribution of sell proceeds realized by the liquidator by sale of asset. Now, this was something wherein Technology Development Board versus Mr. Anil Goyal and others. It was NCLT Ahmedabad bench. In this instant case, the liquidator had distributed proceeds from sale of asset to first charge holder in priority to the applicant, who was second charge holder, without considering the claim of the applicant as a secured creditor. That such a distribution ought to have been made pro rate among secured creditor. It is pertinent to mention here that all secured creditor had relinquished the interest in common pool of liquidation estate. The applicant was one of the secured creditor of the corporate debtor, having 14.54% voting share in COC of the CD. Aggrieved by such a distribution, which recognized inter se priority among secured creditor, applicant move NCLT Ahmedabad bench. The issue to be determined was, the primary issue that was to be decided by the Honorable NCLT was that once a secured creditor has not realized its security interest under 52 of the code and has relinquished to the security of the liquidation estate, whether there remains no classification inter se by joining liquidation, all the secured creditor are ranking equally, irrespective of the fact that they have inter se priority. Observation of the NCLT Ahmedabad bench was, it is settled position that when a charge is created on property in respect of which there is already a charge, it cannot be said that the creation of second charge on the property should have been objected to by the first charge holder. It cannot be said that the creation of second charge on the property should have been objected by the first charge holder, as an existing and registered charge is deemed to be public notice. Emphasis was placed on 53.2 of the code, which provides that any contractual arrangement between recipient under one with equal ranking shall be disregarded by the liquidator if it disrupts the order of priority under that section. In other words, if there are security interests of equal ranking and the parties have entered into a contract in which one is supposed to be paid in priority to other, such a contract will not be honored in liquidation. The whole stance in liquidation proceeding is to ensure parity and proportionality. However, the idea of proportionality is only as far as the claim of similar ranking are concerned. Now, as far as the decision of NCLT is concerned, Honorable NCLT, relying on the judgment of Honorable Supreme Court of India passed in ICICI versus Sidco Leathers, held that inter se priority among creditor remain valid and prevail in the distribution of assets. Technology Development Board versus Anil Goyal, the issue was to be determined by the NCLET. Aggrieved by the aforesaid order, the Honorable NCLT, which has passed, appeal was preferred by the applicant before the Honorable NCLET, wherein the issue raised for consideration was whether there could be no subclassification among secured creditor in distribution mechanism adopted in resolution plan of the CD, as according to the priority of the first charge holder would leave nothing to satisfy the claim of appellant, who too is a secured creditor. And the NCLET has observed that 52.2 of the code stipulates that secured creditor in the event chooses to realize the interest, it shall inform the liquidator of such security interest and identify the asset which is subject to security interest to be realized. Liquidator's duty is to verify such security interest, permit the secured creditor to realize only such security interest, the existence of which is proven in prescribed manner. It is evidently clear that there is no direct link between realization of security interest and assets subject to security interest to be realized. 53 deals with the distribution of assets by providing that proceeds from the sale of liquidation assets shall be distributed in the order of priority laid down under 53. The provision engrafted in section 53 has an overriding effect over all the law in force. The essential difference between two provisions, 52 and 53, lies with regards to the realization. So one, if he is enforcing, in that case, the inter se priority will prevail. But if he is not enforcing or if he is not realizing and is relinquishing the same, then in that case, all the secured creditor ranking parallelly. While section 52 provides an option to the secured creditor to relinquish its interest or realize the same, 53 is confined to the mode of distribution of the proceeds from the sale of liquidation assets. Whether the secured creditor hold the first charge or second charge is material only if the secured. This is what provided. Whether he's holding the first charge or whether he's holding second charge is relevant only when a secured creditor is enforcing and realizing the security interest. Whether the secured creditor hold the first charge or second charge is material only if the secured creditor elects to realize its security interest. A secured creditor who once relinquished its security interest ranks higher in waterfall mechanism provided under 53 as compared to the secured creditor who enforce security interest but fails to realize its claim in full and rank lower in 53 of the unpaid part of the claim. 52, incorporating the doctrine of election, read in comparison with 53, providing for a distribution of assets, treats a secured creditor relinquishing its security interest to liquidation estate differently from the secured creditor who opt for realize the same, as far as any amount remain unpaid following the enforcement of security interest. So one, if I am relinquishing it, then I shall be treated equally with the other secured creditor. But if I'm enforcing it, and after the enforcing the security interest, if any amount which I realized is below the amount of my claim, I will be treated after the secured creditor, I will be treated after the unsecured creditor, and I will be treated in line with the government dues, which rank much after the unsecured creditor in the fifth domain. The first charge holder will have priority in realizing its security interest, provided it elect to realize and not to relinquish the same. However, one secured creditor opts to relinquish the security interest, the distribution would be in accordance with 53 1B2, wherein all the secured creditor have relinquished their security interest. It was held by Honorable Enclave that view taken by adjudicating authority on the basis of judgment passed by Honorable Apex Court in ICICI and Sidgo Limited, and ignoring the mandate of 53, which has an overriding effect and was enacted subsequent to aforesaid judgment, is erroneous and cannot be supported. And therefore, Enclave held that the order of adjudicating authority holding that the inter se priority among the secured creditor will remain valid and prevalent distribution of the asset in liquidation cannot be sustained, and the liquidator was directed to treat the secured creditor relinquishing the security interest as one class ranking equally for distribution of the asset under 53 1B2 and distribute the proceeds in accordance with therewith. So this is the another moot point, and this is what the conclusion is. If I, being a secured creditor, realizing the security interest, in that case, the inter se priority among the secured creditor qua first pari passu or second pari passu, that will prevail. But that will not be having its footing when a secured creditors are relinquishing the security interest, because in that case, there will be no further classification within that class of secured creditor, which is created out of relinquishing the security interest. And last one, as I said, 32 versus 53. And as I said, that 53 do have its relevance while understanding the resolution plan. Because when you see a resolution plan, when you are inviting a resolution plan, and when you as an RP is supposed to place it before the COC for consideration, a resolution plan, you need to make it sure that whether it is complied with 32 or not. So practical experiences reveal that 30 subsection 2 of the IBC has apparently come in a way of the waterfall mechanism. For instance, if a creditor with minor voting share vote against the plan, but the plan is accepted by the COC, dissenting creditor may get more money than a top creditor. And the reason is the amendment in 30 subsection 2, which talks about a dissenting financial creditor to get an amount, at least the amount which he would have received at the time of liquidation. And as I said, at the time of liquidation, he do have two things to compare. What if I relinquish and what if I enforce? What amount I'm going to get as a secured creditor ranking parallelly with other secured creditor if I relinquish the security interest, and what if I'm going to get if I don't relinquish and if I enforce and realize the security interest, at least that amount which I would have received, which I could have received if the corporate debtor goes into liquidation, if I'm getting in this resolution plan, if yes, acceptable, otherwise I can challenge it on the grounds of non-compliance of 30 subsection 2. Fundamentally, two key safeguards have been provided under the code for dissenting creditors. First, 32B of the code, such creditors are entitled to receive amount which shall not be less than the amount to be paid to such creditor in accordance with subsection 1 of 53 in event of the liquidation of the CD in a fair and equitable manner. Second, Regulation 38(1), which talks about this creditor, those who have dissented to the plan, shall have right to be paid in priority over the members of the COC who voted in favor of the plan. So are the two interesting things. One is getting an amount which is not less than the amount to be paid to creditor in accordance with subsection 1 of 53 if the corporate debtor goes into liquidation. And second one is right to be paid in priority over the members, those who have voted in favor. As far as subsection 4 of the code, where the word may is prescribed, while determining the viability and feasibility of the plan, COC may consider the waterfall of priority laid down in 53(1) of the code while underlying value to the security held by the. So, meaning thereby the COC has to determine whether the plan which is proposed by the RA and the manner of distribution or the manner of distribution which is provided in the resolution plan, whether it is in alignment with 53 or not. Word used is may. COC may consider the waterfall of priority laid down in 53(1) in liquidation scenario along with underlying value of the security held by secured creditor. Hence, the entitlement of dissenting creditor in corporate insolvency resolution process of the CD has linked with the amount that such creditor would have received in hypothetical situation of the corporate debtor being liquidated. In landmark ruling of Supreme Court in case of Committee of Creditor of SR versus Satish Kumar Gupta, Honorable Supreme Court, while upholding the constitutional validity of the amendment made to 30 subsection 2 of the code, inter alia observed that this provision was beneficial for dissenting creditors, as such creditor would have been entitled to receive minimum amount in CIRP. Supreme Court has held that the decision to approve a resolution plan ultimately depends upon the commercial wisdom of COC, and the word may included in 30 subsection 4 of the code implied that COC has been granted a discretion as to look at certain consideration while approving a plan. In Supreme Court in the matter of J.P. Caniston, this is a J.P. Kensington judgment while deliberating on the rights of the dissenting creditor, relied upon the SR Steel judgment and held that a resolution plan would be deemed to be in compliance with the provision of 32 if either actual payment to the requisite amount was made to a dissenting financial creditor or if the creditor was permitted to recover such money by enforcing security interest. So basically, as far as this all provisions are concerned, I would like to say one thing, that the code is still evaluating, or still there are a considerable amount of clarity. The considerable portion is the gray area, which in a situations are being treated as far as the need of that situation. And there is no hardcore rule or hardcore formula which is prescribed, especially in case of this section 30 subsection 2 vis-a-vis 53, which talks about a dissenting financial creditor should at least get an amount which he would have received at the time if the corporate debtor goes into liquidation. Because in the liquidation also there is a possibility, what in case if he enforce and what in case if he relinquish. Other thing where there is a consistency is required is pertaining to section 36(4), where it is stated that the employees provident fund and gratuity and pension fund, this is something which is not forming or that shall not be considered as a liquidation estate. This is not an amount, or this is not a money which pertains to corporate debtor. This is just an amount for which the beneficiaries are none other than the workmen and employees, and it should be kept out of the liquidation estate. But liquidator face the challenges. See, liquidator cannot utilize it for the purpose of waterfall mechanism, but liquidators are under a huge challenge when they get a resolution plan, because what we have seen, that if the corporate debtor is being transferred, that transferee shall be liable to contribute to that fund, which was actually an obligation and onus on the part of the corporate debtor. So considering this scenarios and considering this situations, there is a clear-cut regulation which make the things very clear that if I'm the liquidator to a corporate debtor, in what manner I have to treat this fund, how to utilize it, what in case if the amount was not contributed to this fund, whether I can use my asset of the corporate debtor or liquidation asset to make that shortfall good. this is something which actually requires some amendment, some clarification, some circular, or it requires a further clarity from the board or from the ministry. So I would like to stop here. I would like to give an end to this discussion, and would like to invite if you have some comments in case if you have some contrary views, in case if you have some own say, or if you have something to discuss or deliberate upon. Section 53 of the waterfall mechanism, if you find it flawlessly, so practical challenges are always going to be there, and this practical challenges are the only reason which on basis of which the actual issues will be addressed, the actual issues will be taken care of by the board, by the ministry. But at this moment I must say that the rainbow papers, the concerns pertaining to the statutory dues as a secured creditor is no more being considered, is no more being actual concern for the resolution applicants, or this is not a moot point of discussion before the NCLT or NCLAT, because things are very clear that the objective of the code is paramount. The preamble of the code is very clear that change in the priority of the payments and the priority with regards to government dues always fall after the amount payable to the secured creditor. So the language of that statute, whether it is a state act or central act, is very relevant before classifying a creditor or government dues as a secured creditor. If you have any concern, you can either drop the question in a chat box, or else you can directly raise a question so that we can have a discussion upon. In absence of any questions from your side, it will be presumed that there is no point to be addressed upon, or there is no further point of discussion or deliberation in this topic. May we conclude, Anjali?
We can conclude.
Thank you, ma'am. Thank you very much.
Thank you very much, sir, for sharing your thoughts and experience and knowledge about the topic. Thank you very much for giving us your time and giving your input. Sir, you are requested to please share the presentation.
We'll do that. Thank you.